charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican police service Latino. I didn't ask you to interrupt me.
Is that correct?
Alrighty. I'm getting ready. Welcome to the Court of Public Opinion. I'm the Recovery Addict. Thank you very much for joining me this morning. We have so much to talk about. We really do. Let's see. Hospice Jess, I get a fancy milestone chat. Remember the good old days? Way back in the day. 10 months. Hospice Jess, do you remember the good old days? It was about 10 months ago. Let's see. Taminator 61. Oh wow, 30 months already. Time flies when you're with good people. Thank you very much, Taminator. We sure are. I also have to say, huge shout out to Tanil Suzanne. Tanil, this is a first time offense for you, but you have just won the internet. And you did that by being first in chat today. Congratulations, Tanil. It was simple. All you thought you were doing was saying hi and being nice, but no, you were bidding on internet ownership and you won. First bid always wins on that one. So congratulations to just make sure the internet is up and running for everybody else.
With more experience.
And send somebody with more experience. You're going to do great, to know. You really will. We'll send you this. We'll send you the standard operating procedures and everything. You'll be good to go. All right. We have. Let's see. Reverend Beasy would never want to be anywhere else with the zebra. I've got my zebra right here. Thank you very much, Reverend. All right. Let's see. We've got a few more milestone chats. Also, well, no, not that button. This button right here. Sore throat says almost a year, pal. Almost a year. We're getting there. Wow. I will tell you, I was not feeling well over the weekend, so I'm hoping to feel good all through the day today. So wish me luck here. Maisla, welcome to the gallery. Look at this. 10 months as well there. Congratulations. I was talking to my family this morning. Hang on. We'll get to the important stuff in just a second, but we'll get to the birthdays and stuff. That's what I mean by important. My family is important. Don't get that wrong. Judge? 3 months for Hannah. Love my courthouse and love this channel. Thank you for what you do, bringing this community together. We all love the same thing. We do. We all love the same thing. Let me just tell you. I was talking to my family, and let me just send this to my computer. MacBook Pro. Beep, 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 beep. It's waiting. It's going to work. Okay, it arrived, and now I've got one more to send. This one right here. We were talking about a funny occasion, and I realized I think I may have led you astray. Back around, chats are not on screen. Fix that. Sorry about that. Thank you, Rudy, for telling me the chats were not on screen. So we have to go back and say, Tanil, congratulations. Let's see. Reverend Beasy, I see you there. Sore throat. Maisla. Hannah is here. Krista, yay for me. Krista, good to have you here. Becca Lynn, can we do a poll whether we think Hannah will testify? That's going to be today as well. We're going to find out. Nicole Wise, welcome to the gallery. Good to have all of you here. Anyway, back in when was it? And Maisla just gifted a gift as well. Thank you, Maisla. Back in October, around Halloween time, I was telling you about a story about me creating my only costume I ever built, and I just realized that that is not entirely true, and that there was one other costume I did build, and so in order, duty being a de facto officer of the court as I am. Here on this Court of Public Opinion, I felt the need to correct the record and inform you that there is, in fact, another another costume that I built, and this one comes with a story. So just before we share this story with you, let me give you a little backstory. This costume was not made for Halloween. It was not made for Halloween. It was actually made for another holiday, festive occasion, a little bit later in the year, basically towards the end of the year. And this was a very it was a difficult task to create this costume, because I knew immediately upon undertaking the costume creation that it was going to be judged, because this was a contest. Oh man, I need to switch to this camera so I don't spoil it here. Just 1 second, because I have to open this. This was a costume contest that I was entering, and close that down, save the changes, reload, put it up again. Okay, there we go. Work this time. There we go. Okay, so I'm dragging this out, but now I'm caught up because I've got everything ready, so I can stop dragging it down. Anyway, it was a costume contest. It was a Christmas costume contest, and specifically a Christmas sweater costume contest. And there was a big party I was attending, and we were all encouraged to create our own sweater or wear a sweater from our collection that would win this contest. And in my mind, I envisioned what would look best on a Christmas sweater, but of course, Rudolph soaring through the sky. And so in my head, I built the vision of what it would look like for Rudolph to fly through the sky, and how amazing it would be. And I managed to recreate it on a shirt. I used a blue shirt for the sky, and then recreate with Rudolph on the shirt. And the problem is, I built it from the perspective of Dancer, who is the second Rudolph, or the second reindeer in the chain. Rudolph runs along straight, and then there's the view from Dancer. Well, if you're not the lead reindeer, the view never changes, right? So I built this shirt, and then realizing that it was not quite complete the way it was. I added something a little bit festive as well, which was a means to store my favorite Christmas treat, which is oops, let me put this one down here. Which is chocolate covered raisins. And so I have a little baggie of chocolate covered raisins that I could snack from as I wander around the party. And apparently it won. It was a top sweater that year. So when I say that I've never built any other costumes, this is the other costume I built, and I just wanted to set the record straight. But it won. I took Tom prize in an ugly sweater contest at Christmas time. So there we go. All right. That said, that gives you just a little scope into my weird sense of humor. Let's see. Nickel Wise, welcome to the gallery. Thank you very much. Look at that blue courthouse by your name. Thank you. Let's see. I'm now on several lists. Let's see. I've got messages coming in and buffer sounds. I think we have birthdays today. I know we have birthdays today. DL, Krista's son Jared. Okay, so I have to parse out the names that I'm not singing to. Just 1 second. So DL, Jared, Darian, Ashley's husband, Austin. Oh, sorry, Austin. I've got Holly and ASMR Molly. That's the same person, I believe. Alita Lay's niece, Violet. We're going to sing to Violet. Okay. And Pamela and Angela. Whew, that's a lot. That's like a 2-verser, guys. And Deb. Oh, wow.
I'm not a cat.
Whoo, guys, you've been hard at work organizing all the birthdays this morning. So I think I've got everybody. we're gonna sing birthdays because we have to get we're getting ready. Court's gonna start in about 20 minutes, and we'll have everybody together for that. All right, let's see. Holly has Lost Souls. And Lost Souls, yes, I'm also ASMR with Molly, just to confuse people. See, I'm following this.
I was kicked back, taking it easy.
Okay, I think that's all. There are a few belated. That's all right. There's a few belated. Okay, here we go. I think we've got everybody. My daughter Harper has a birthday. Well, there's Harper. We'll throw Harper in there on the end. Okay, this is going to be 2 verses. Holly D.
Scratch all that.
We're just going to sing D instead of D. Holly D, Jared, Darian, and Austin, and then Violet, Pamela, Angela, Deb, and Harper. Okay, you guys got that? I'm seeing nods all around. All right, as we get kicked off, Dilly Pickles, congratulations on your 11 months of support. Thank you so much. Here we go. Everyone ready? Warm-ups. La, 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 la. Here we go. 2 verses. Don't forget the interlude. Don't do it like I do and start singing the second verse during the interlude. That's embarrassing.
Is that correct?
Here we go. Holly D, Jared, Darian, Austin. Happy birthday to you. Happy birthday to you. Happy birthday, Holly D, Jared, Darian, Austin, and Violet. Oops, I got next one. Happy birthday to you. Okay, so since I squeezed Violet in the first verse, now we only have Pamela, Angela, Deb, and Harper for verse number 2. So we can slow it down a little bit for the names. Oh, I'm feeling the vibe today. Happy birthday to you. Happy birthday to you. Happy birthday, Pamela, Angela, Deb, and Harper. Happy birthday to you. Wow, that was fantastic. We have become a choir to be reckoned with. I think we should cut an album, maybe. I think we should cut an album. Of course, it will have to have like 365 songs on it, and everyone's birthday will have to be included. We call it the birthday album. And it would be a hit. It would be a hit everywhere. Everyone's singing our songs. Happy birthday to everyone who's celebrating a birthday today or in the recent past. If we missed you over the weekend, I'm sorry. Thank you for spending your special day with us. There's a million places you could be. You choose to be here. Thank you. That means a lot. Or maybe you're here on the rewatch crew because you're out getting free pancakes. Either way, it's all good. It's all good. Wonderful, wonderful. All right, we have court coming up today. We have the Hannah Payne trial. Let's see what we got. Hannah Payne, are you ready? I think Hannah Payne is ready. Turn this off. Reset that one. All right. Ooh, great start for the day. Great start. I appreciate all of you making that happen. Gerda. The one person in chat who is not singing just owned up to it. Gerda says, "Confession: I don't sing. I just listen to your voice." Mindy, we've got our fingers crossed on that one. There's a possibility we might be able to. We are still waiting to hear from the court, but let's see. We just got I got a text in from Melissa, who lives in Clarksville, Tennessee, where one of the devastating tornadoes hit on Saturday. I don't know the location. Is it Red Cross that's taking donations? Who's doing the donations to help that? Just what you can tell me. Let's see. Okay, we got some great advice, some great pictures.
I'm not a cat.
Okay, I think we're all caught up. At least we're caught up as we're going to get. Maya trial on Friday, that is happening. For those that are asking, what's the Maya trial on Friday? Didn't that finish? The Maya trial has some motions that were made after the verdict came in. And a couple before, but one of them was a motion for sanctions against the defense. The defense has asked for directed verdicts on several different things, including new trial motions. They've filed complaints about juror number 1. They've updated their complaints about juror number 1. Lots of back and forth. And all of this is going to be wrapped up in a beautiful 4-hour hearing. that happens on Friday. So we can't wait for that. That's going to be very, very telling. If the defense loses like they lost during the trial on that hearing, it's pretty much over for them. We'll see, but they might win some things. The judge, before this all ends, the judge might knock down some of those settlements. I think even the plaintiff, I think Nick and Greg were saying that there's one charge that might be reduced by about $5 million, or one verdict that might be reduced by about $5 million. But all right, let's see. You live in Springfield, Tennessee. Yeah, I heard they had just terrible tornadoes, and I saw a couple of videos. There was one video that the video went viral pretty quickly, but the tornado was coming in. It's being filmed, and then it hit, I don't know, a natural gas plant or something. It hit something, and there was a massive explosion, and it basically just detonated inside the tornado, right in the very center. And so there's a huge ball of fire that just gets sucked up the vortex at the same time as it's exploding, and it just like nuked the tornado. And so some of the weather guys are like, hey, maybe we found the fix for tornadoes. We can just bomb them. We can just bomb the tornadoes, and that would stop things. So anyway, there's a lot of discussion about that. I think there's actually some scientific work that's going on right now just on the theories that develops. But crazy. Please hope everyone stayed safe and is okay. If you got affected by that tornado, thoughts and prayers are with you. We'll look for the locations to donate as well. All right. Theoretically, if I were to drive down to Sarasota, does one know if there's a 24-hour Walmart where I could sleep in the parking lot the night before? Now I've got some loud music played somewhere. I think it's outside. Nope, it's inside. It's Wizards of Winter is what I'm hearing. Okay. Hopefully you're not hearing that as well. It was an electricity substation. Wow. It crazy. It was a fire-nado. It was dangerous. It was crazy. I watched a little bit of Ryan Hall, only because Weather Watch wasn't streaming. So we got to twist his arm and get him streaming. But just crazy, that line of storms that went through. We actually had a couple tornado watches here where we are as well, but nothing developed. Sorry, couldn't sing, off work, sick. Lynn, I'm sorry. I hope you're feeling better. Hope you're feeling a ton better. Get better soon. A couple people in the Tennessee area checking in. I'm glad to see you checking in. Hopefully you're okay. Okay, we have... there's a Publix. There's a Publix down there. Dr. Joe's live stream is 4 p.m. Eastern time. Yes, and it's just I believe he finally accepted his little nickname. And it's just a chat with Dr. Goodhair. So that's going to be tonight. Hopefully our court will end by then. We'll see what happens. But let's see where we are right now. We are, boom, right here. I need super source. Box source 2 is 6. Nope. Box source 1 is 6. 2 is 2. Where's my camera 6? It's not working very well for some reason. We need that camera to work because that's our objection counter. We're up to 26 objections, by the way, in this trial, and only 2 of them have been ruled in favor of the defense. Interesting stat. Let's see. We too low? I just got your reference on that one. I keep coming back to the gun jam. Typically, the only reason the guns like the XD jam is due to limp wristing. I think there was a major struggle. He grabbed her wrist and she shot. Limp wristing or possibly blocking the slide as well. If somebody's hand was on the slide, that would absorb some of the force, and it would explain that.
Have them send someone with more experience.
Cheese Curd Havoc says we have slightly fewer objections here than in the Maya trial, just barely. We have less than half the objections Dr. Goodhair got during the Maya trial. He had 82. Do we have time to go back and watch the police body cam footage? Susie, I'm hesitant to do that, only because first of all, it's very hard footage to watch. Mostly it's the audio, but there's very little. And honestly, afterwards, talking with Mrs. R.A. about this, I agree with her. That video is almost entirely prejudicial. Why? Because it doesn't cover anything about what she did except for the moment the cop arrives. That first 5 seconds while she's there, that's the first. That's all there is. That actually relates to her actions there. Everything else is, and look at the harm it caused, which would be prejudicial, right? There's no, I didn't see anything in there that would be, and here's the evidence of what happened. It's just audio of somebody in pain and somebody, expiring. Let's see. Let's see. That first 5 seconds said a lot to me. She was extremely calm, Vicky. I will say I was surprised when I watched the video when you do see Hannah on there. The officer shows up on the scene, basically asked, what happened, and he's like, oh, somebody shot somebody. Where's the gun? She's like, oh, it was here, and I think she said, I did, or I did it, or something to that effect. And she's on the phone. She's on the phone with dispatch. Okay, that's my understanding. She's on the phone with dispatch, and she stays on the phone with dispatch and just hands the officer the gun, just as if she's just talking with a friend. Very, very calm, but very interesting. Let's see. Bryce Rhodes, I think, doesn't jury selection start on that one this week? That might be our next trial, depending on the timing. That might be our next one. We'll see. We'll see on that one. Depends when this one ends. Don says, all right, just an FYI, I went into the ER last night for an injury on my hand, and even after I explained how it happened, they came to a completely different conclusion. Very frustrating. Kathy and Pam says, I ventured into the anti-Maya Reddits over the weekend, and boy, are they obsessed with Jules. They're also in this chat, apparently, a lot, and saying very nasty things about some of our comments. That's the beauty of the First Amendment, and their right to say what they want. I will defend their right to say very hurtful things. I just don't want them said here. Hello from a very warm and unexpected this time of year in Montana. No complaints, not a fan of snow, although I've lived here all my life. Montana, normally you think cold.
When are we going to break for lunch, Judge?
I've got a friend who is homesteading up in Montana, and she always sends pictures of bears and wolves outside the cabin. It covered what she did to him, the effects of her actions. Now, Becca, I hear that a little bit, but as far as the video or the audio, there's audio where they say, where was he shot? But the prejudicial value of that, of somebody literally groaning in pain as they're expiring, I think is much greater than the probative value. I'm actually surprised there wasn't objection to that coming in. Kind of sort of in the way says, I don't know much about guns. Does the jam mean the trigger was pulled twice, or does the jam happen when the next bullet is loading? I'm confused. Kind of sort of in the way. It's when the next bullet is loading, or the first one is being ejected. Okay, imagine every time a gun is fired, there's a shell, a casing, a cartridge that expels a projectile down the barrel. At the same time the projectile goes forward, the gun, if it's a semi-automatic like hers was, it cycles the action, meaning the top slides back, and as it does that, it grabs that casing and pulls it and ejects it, kicks it out the side, and then grabs the next one and slides into place so it's ready to fire again. And this happens in a blink of an eye. It's so fast. So you can almost fire as fast as you can pull the trigger. But in this case, with this first shot, for some reason the gun fired the projectile out the barrel, but the action didn't go back far enough to eject the casing, the empty casing, out of the chamber. So when it slid back forward, that empty casing was still in place. So now it would not fire. would not fire again because there was a spent cartridge there. So you would have to manually cycle the action to eject that casing, feed the next one in, and then it would be ready to fire again on the next trigger pull. But when the officer took the gun from her and cleared the gun, he cycled the action, it ejected the spent casing from the shell. So only a single bullet had fired. But that's a great question. Phil says, I'm not a cat. I'm one of the people. Yes, that is a great one. Tayo Toys, thank you very much. Good to have you here. Great work, by the way. Nikita says, maybe an unpopular opinion. I feel she had the youthful self-righteousness and her heart may have been in the correct place, i.e. trying to prevent further accidents. I think it was initially, Nikita. I think initially, I mean, that's what we hear her tell dispatch when she seems calm and cool and collected and just barely engaging in the scene initially.
I'm not a cat.
Oh, you had it right. So I just confirmed it. Camilla says, hey, from Sweden, all this guns in America and the other country is mind-blowing. Happy I'm living in Sweden. Very different. We have very different philosophies regarding them. Grace Sanchez says, I'm having surgery tomorrow and I'm super scared. I have had anaphylaxis during surgery before. Please pray for me for no complications. Grace, I am. You will be in our thoughts and prayers.
Is that correct?
I hope everything goes just absolutely beautifully and wonderfully for you in the surgery, and then I can't wait for you to check in and tell us how it went perfectly when it's over.
Bring the jury.
Our hearts go out to you, Grace. The video was disturbing. They didn't need to show the whole thing. They just wanted it to upset the jury. See, Diamonds, that's what I'm saying. The part that upsets the jury, I think that is the prejudicial side. That's the prejudicial side instead of probative. Okay. Let's see. I wouldn't take an enemy to J-Hatch.
Are we going to address subject matter jurisdiction?
I don't know about J-Hatch. Here's what I feel. I don't think what we know about J-Hatch is what J-Hatch is today. I'm thinking there's some things that need to update and change, specifically in their legal department. Let's see. Courtney just sent a text saying, hey, proud brag moment. My son was promoted to E4 yesterday, and I got the privilege of pinning him in front of his whole company. That is awesome. That is really cool. Congratulations. Let's see. Salvation Army is accepting donations that are helping in Tennessee. That is wonderful. Let's see, lots of text. All right. We have a 9:30 start time, which means we have a minute and a half before we're supposed to begin court. But this judge has been a little late because oftentimes either the jury's not there or the defense attorney is not there. But it's supposed to start in just a moment, and I just haven't seen any action on the screen yet. Let's see if we can pull up another feed.
When are we going to break for lunch, Judge?
When are we going to break for lunch? Okay, that one's ready. So let's switch this. I still don't have my counter.
Don't miss the forest for the trees.
Okay, we're trying to get the iPad working so we can have our counter, but it's not playing nicely. It's coming in 6, which is right here.
I'm not a cat.
Man, frustrating. All right.
Bring the jury.
We should do a timer for break times versus actual court time. I think break time would be winning for sure.
Ella stole it as well.
That was terrible.
Welcome to the gallery, Casey. Good to have you here. Thank you so much. Blue Courthouse. Let's see. Amber C, which one are you talking about? You just roll back.
All rise. Court is now in session.
Figured out a way for you to do the poll talked about. Question 1, against carrying. Question 2, for carry but think guilty. Question 3, for carry and innocent. But wouldn't we need? We'd need two against carrying. We'd need against carrying, but not guilty. Against carrying, but guilty. And I think that would be the smallest. Against carrying and not guilty, I think would be the smallest percentage. For carry but guilty, for carry and innocent. Let me try this a little bit, and we're not trying to make. I'd ask that we not chase this rabbit. This isn't a
There's
conversation
a
about guns. I realize it's a key part of this case, but this might be interesting for us just to look at. Let's see. Start a poll. How do I word this? Sorry, trying to spell things right. And I realize that YouTube has all sorts of issues with polls showing up properly. And even this poll is going to have problems because they're qualifying situations and things. Add an option. All right, let me read you what the poll says for those who are not going to be able to see it. The poll is, what is your opinion on this case? The first answer is against carry, not guilty. The second answer is against carry, guilty. The third answer is for carry, not guilty. And the fourth is for carry, guilty. Now, when we say against carry, that's whether or not she should have, that's your personal beliefs about whether people should carry guns, just broadly, whether people should be allowed to carry guns. So if you're against that, you would say, I'm against, and then you would choose either guilty or not guilty. And if you're for that, generally, not in this specific case, we're not looking at specifics, but then on this case, obviously, is very specific. So how's that for an unscientific poll? It's up. We'll see if we can figure out how it works here. Wow. Immediately have some interesting numbers. Objection counter. I'm trying to get this working. I'm going to have to get up and walk around to get this working, though. I think the problem is it's not charging either, which is also bad. Hang on. Ashley says, I sent you info to the burner over the weekend about a trial happening in January. That should be interesting. I'll look at that. Remember, the end of January, we should have Sarah Boone. So that'll be interesting. Guys, objection counter does not want to participate. It may have got our last objection reading off of it, but we'll see if we can figure it out. Court is late. They're 6 minutes late this morning. Let's see. So who asked this? Let's see. Pamela. Let's see. Okay, let me, Pamela, you've got some questions about a recommendation. I've got one for you. Let me text you a link. Does that work? I'll text you a link. All right, as we sit here and wait for the judge to make her grand entrance, JPC gifted 5 memberships. Thank you very much, JPC. Good morning to you, and good morning to the 5 people who just received those. Congratulations. It's very early for a poll, especially one this heavy. I mean, this is a heavy poll. Well, I think we're going to go ahead and wrap up the poll so we can see nobody over 50% right now. Okay, so this is interesting. For carry and guilty. This means individuals who generally believe. Oh, I think the judge is going to be walking in any second now. Generally believe that carrying should be allowed. And guilty, 47%. Against carrying guilty, 27%. So combined, that is 64%. So 2/3 of us think that she's guilty for one reason or another. For carrying, not guilty, 18%.
Okay, all right.
And for against carrying, not guilty, only 5%. Out of 508 votes.
Certainly.
They're going to approach really quickly. I'm going to boost the audio because this is terrible audio this morning. Let's see. Let me switch to camera 3. 2. Settings, speed, normal, quality, good. Okay, so we're good on all that. Trying to get the audio to be perfect here. Let's cut back to 2 and pause for a second. So they're doing a quick sidebar. We can't hear what's happening right now, but hopefully soon we will. All right, we'll get this figured out. This one down, this one. Oh, that's what we need. Okay, I found the problem. I found it.
Further that the court has to address before we bring the jurors in?
Nothing from the state.
I believe there was one more thing. Listening to the 901 tape again last night, and I know probably should have been objected to the first time.
Yes.
Turn on your mic, please. Turn on your mic, please. Court reporter can't hear what you're saying.
The video.
Hello. Okay. Yes, ma'am. Early in this case, when Judge Malone received the case, I went to go have a bond hearing, and the grounds for the bond hearing were to reconsider, plus the 911 tape appeared to have a 2-second gap that was unable to be explained why. The 2-second gap you could hear from the video where it started and then where it came back in. And it came back in 14 seconds later when there's only a 2-second gap. So I was unaware of why a 911 tape would have a gap like that. And how do you fit 14 seconds into 2 seconds? During that hearing, I think the state stipulated that there is a 2-second gap where 14 seconds should be in the 911 tape. And I believe it's the one that's been presented here. I listened to it again last night just to make sure that the gap was still there, and it appeared to still be there. So I would object to being played again based on the fact that there is an issue with that 911 tape. I don't see procedurally how I could come back and try to have it redacted or taken back out of evidence. But I wanted to make the court aware of that gap that was there when it was discussed in the procedure of this court, not this court, but the previous court, and what was addressed and what was stipulated to. So I'm not sure how we would go about, and that's what I was looking for, some kind of law or something to present the court that would be able to stop or take the tape out because it has been altered with. The one 911 custodian who got up on the stand said there was no way really to alter it in any form or fashion. However, it was altered, it appeared altered. When I addressed it early on in this court proceeding, the state didn't have an answer either, and they just stipulated that, yeah, there's a gap, and yes, there should be 14 seconds in there, and if necessary, we could, I guess outside the jury's presence, play it, and I can tell you exactly where it is, and you can compare it to the video and see where the gap is and what should be there and played, but was not.
Any response from the state?
Sure.
I'm not sure what he's talking about as far as stipulating to anything. Judge, the foundation for those calls was laid. The witness testified unchallenged about what could and could not be done to the calls as they come into the call center. When I tender them into evidence, there was no objection. And so those discs are fully in evidence and can be played for the jury. And I don't think it's appropriate for defense counsel to try to argue that it's been altered because that was the testimony that was elicited that it hadn't been, and then he did not object. And it's too late to go back and try to claim alteration and things of those lines. He's had these discs for 4 years. 4 years.
She knows it's been altered. And
if there was something incorrect about them, he could have certainly brought his own expert. He could have done something. He could have objected. None of that has happened. The calls are in evidence, and they can be played for the jury at this point, and we're going to play them this morning with the court's permission, obviously, as we discussed last week. And to try to come in now and claim that they've been altered when he didn't object or lay any foundation for that, there's literally zero evidence that there's anything wrong with these calls. There's a lot of operators in a 911 call center. If there's other noises or anything else that's going on in the background, it is what it is. But the calls are in, and I think this, I don't know what it is, but this, I don't know if it's an objection or this argument is overwhelmingly untimely and without foundation.
And
the audacity.
I want to report back to my motion to reconsider bond back when they put Miss Payne back in jail because it got indicted. The case got indicted within 4 or 5 weeks, an unheard of time. And my motion was filed, and in that motion, it did describe what was heard on the tape, what the concerns were. And the prosecution or the assistant ADA at that time came in and said she would stipulate that there's a 2-second gap where a 14-second video had appeared to be what should have been there. So this all should be on the record based on my previous motion that I filed with the reconsideration of a bond motion. It was heard, and it was decided that she would get a bond based on maybe some discrepancy or something being altered. So there was a bond given based on me playing the audio and playing the video at that time. And the ADA, it wasn't Fowler, it was I guess a stand-in. And she stood there and said, I stipulate there's a 2-second gap where 14 seconds should go in. And the judge made that decision to give her a bond based on me presenting that evidence. So there should be record of it. There should be a motion filed that described it. And there should be an order where she got a bond based on that. So there is record of this. And once again, as for timely, I guess I should have caught this earlier. But I wasn't sure which 911 because it had been so long ago and the court had already made a decision on it. So that's why I was looking for the law to see what I could bring in to use to bolster my argument, besides just saying I want to bring to the court's attention that this 911 tape had been altered.
Okay. Are you checking? Going back?
There's a transcript, but again, it doesn't matter. Before this jury, the state laid the foundation for those calls, laid the foundation for any ability to alter them, tendered them, and they were admitted without objection.
But she knows it's a lie. I think that's a huge problem.
If he had an objection, that was the time to make it. That is what I mean by untimely. If he thought 4 years ago there was a problem with the discs, then something should have been done for trial. That was not a trial motion, and there's literally zero evidence that she got a bond because of a gap in a 911 call. Zero evidence of that. She got a bond because she'd already had a bond, and when we re-indicted her, she was rearrested. She'd already been on bond. So that is an attempt to mislead this court. And that's not why she got a bond. She got a bond because she already had one and had already been out. And the judge just basically reset the bond and put her on an ankle monitor.
That is incorrect, Your Honor. She denied a bond when she got rearrested. We went in front of the court and asked for a bond. She was denied a bond. And the judge was hesitant to allow that bond until I filed a motion to reconsider. And I brought evidence in there showing that there was a gap in this tape and there had been some kind of alteration of this document. And at that time, she decided to give her a bond. And it was a much higher bond than she already had done. So she had to keep that bond that she already paid for intact and pay an additional $300,000. So it was not given because she already had a bond. That was my first argument to get a bond, was the magistrate judge came to the conclusion that she was eligible for a bond and gave her a bond. Why would this court deny a bond? So I had to bring it back up in a motion to reconsider. And I put the facts in there of the tape being altered.
Okay. If I may, Judge, I have the transcript.
Okay. The transcript of the
bond hearing, yes, Judge, where it was fully explained. And it was ADA Fowler.
Then obviously that's the wrong. It was the motion to reconsider, not the original motion to bond.
By Mr. Fowler to the 911. It was a different custodian of records. Can you kind of just briefly explain to us what's going on during that silent period? The explanation. The way that the server works, that this audio was saved on, the best way to describe it is it's similar to a voice-aux recorder, if you're familiar with those. It only records when there is actual activity above a certain level. In other words, if you have a voice-aux tape recorder that you used in college, if you set it on a corner of a desk to record a seminar or something, if there's a pause in the lecture while the instructor takes a breath, for example, that recorder may stop. Question. So it's not as though the audio was edited to cut something out. It's just that the system can't hear, and so it stops for a moment. Answer. That's absolutely correct. It has not been edited in any way. And I'm trying to look through Mr. Tucker's cross-examination of that foundation witness.
And, you know, this is not the motion I'm talking about. This Mine is the motion to reconsider bond in front of Judge Malone. Fowler had already left by that time.
Problem is, he doesn't
This is
have
in
his
front of
own.
Judge Malone.
Now, Fowler had already left when I did the motion to reconsider.
No, the motion
That
to reconsider.
specifically discusses what the issue you've raised, Attorney Tucker, on this. You raise it again, but that specifically addresses what you're claiming is 2 second, but really extends into 14 seconds.
What I was addressing there is it sounded like it was radio silence. And I was asking, is it common to have radio silence instead of hearing what is being recorded? And the one to be considered addresses exactly a 2 second gap where when you see it on your computer, it drops and it comes back, the ball underneath it. And I specifically why there would be a gap taken out that has her in the video screaming stop, 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 whereas the audio of the 911 has none of that. And then it comes back right with, oh my God, ma'am, he just pulled the trigger of my gun. It was a gap that had that part taken out. And when I asked the state about it, we brought it to the judge's attention. There should be transcripts of it.
I'm holding the trans. This is the motion to reconsider bond after pretty document. I'm holding it.
No.
I'm reading from it. It's in front of Judge Malone. It's in July of 2019.
This is spicy.
That's the discussion about the 911 call.
And that was the motion to reconsider.
Fowler was not present at that motion to reconsider. And I'm trying to pull up the case summary so I can get the exact date of it.
The only other motion to reconsider, Judge, was a motion that I argued when she asked to have her ankle monitor removed. That's the only other. That's the only other hearing. But this is the motion because, as the counsel is pointing out in his opening of this motion, she'd already made the bond. She'd already started her life again, and then they indicted her and added charges. So this is the motion to reconsider. And the 911 call is discussed and very clearly explained. So his answers to that question, he's already been provided the answer to that question.
So there was a motion for reconsideration of bond and briefing support July 29th, 2019. And then there was one July 1st, same thing, with an emergency motion for reconsideration bond and briefing support thereof. So was that the July 29th?
I think that's when you would see it being filed. The hearing, it looks like, occurred on July the 12th. Sometimes there's a delay in the filing, and you're looking at CPU-8.
And then that motion to reconsider was denied, it seems, the 7th of August, 2019.
So there does have to be another one, because if it was denied, we know she got another bond. I don't know when that one was.
Okay.
But the answer to the question about the 911 call has very clearly been answered. There's only one witness who has testified to the foundation of the 911 call, and it was admitted without objection. So I think it's just too late. They've already heard it.
Here's my problem with this. Ready? Admitted without objection.
And he has no good faith basis and no foundation and no evidence in order to be able to argue to the jury that it's been altered. There's no good faith basis to do that.
Your Honor, I have a good basis. If you would like to hear the 911 tape and look at the video, I can show you exactly where it cuts off. And you can hear, if you watch the video, you can see where the video shows the part that's missing and then comes back in with her screaming, man, he just shot himself and pulled the trigger of my gun. There's a gap, 2 seconds. And then there's 14 seconds of that video that should be there. So there's your good faith effort. Good faith basis. And that is what occurred, and that's what I argued on the motion. The latter part to get a bond. And upon hearing it in court, the judge came to the conclusion that she would get a bond because it appeared like there was some kind of alteration of the 911. after talking to the 911, Tim White, or the custodian, I was asking specifically why there was radio silence and why there was no one talking during that period of time that they're supposed to be telling her not to chase. And then I asked about the other tape, and Alan went through it methodically and said, these cannot be altered, but yet it appeared to be altered. And that was my argument. That was in front of Judge Malone, and that's what gave the basis for her to give a bond, which, like I said, was an extremely large bond since she'd already made one. And that was my understanding as she turned and said, okay, we're going to give her a bond, but it's going to be this amount. So I know I can't do anything about it being submitted into evidence, but if there's some way to, upon the court's approval, explain that there is altercation, if we need to play it for you to come to your conclusion of it, I have no problem with that.
And this court is not a finder of fact. The court can't find that there's alteration. There is no alteration. It has been explained. The only evidence before this court is that it can't be altered once it's saved on their system. And then his question about those quote-unquote gaps are explained, because if there's not a high enough volume level, then it stops recording. It's been explained. There is no mystery here. There is no conspiracy here. Nothing has been altered. There's no evidence of that. And it's in evidence, and we just need to deny I don't know what motion this is, but it's in evidence. The jurors can listen to it as many times as they want to. And that's all there is about this.
Okay, let me ask you, Attorney Tucker, can we play that specific portion?
This is big. This is big.
We went through and tagged exactly where it was, and then, like I said, you can hear where there's a gap, and there's nothing to play. And then all of a sudden, it pops back up with her saying, ma'am, you just pulled the trigger of my gun. But if you hear where it stops, and you put the video where it stops and listen to the whole video, you'll see there's 14 seconds of that video, but there's only a 2-second gap. That's why I was asking about Tim White, to find out if he was going to be here, if he was going to be here. He was the one who was the custodian and head of it at that time, who would have to explain. So if the court would like to hear it, they can cue it up, we can cue it up to where it's at, and then compare it to the video. And in the video, you're going to hear her screaming, stop, stop, stop. In the 911 call, you don't hear that at all. And you hear how loud she is, and you see where that phone is right there below her. You would think it would catch that audio, but it doesn't.
But there's an explanation that if it doesn't rise to the level where it can be recorded, then it wouldn't be. But here's what I'll do. If we can just quickly play the video with the audio to see what it is that you're trying to establish, Attorney Tucker.
Okay, this will be, if he can get this pulled off. Where's IT?
Ben is here.
Okay, the reason why I think this is a big deal. First of all, yes, he's late. He's late on his objection, right? Very late. It should have been timely. But if this has been modified, if this is not accurate, and the assistant district attorney knows that it was modified, and she elicited testimony saying that it was not modified, that's a problem. That's the problem I'm saying. Looks like Hannah's putting in the work. She's connecting all the cables and everything. So that's why I say it's a problem. I think it's a problem for the ADA for her to stand behind testimony if she knows that it's false. But he's saying is the gap doesn't match the gap. The tape should be altered if there's 14 seconds of missing time, but the call is only 2 seconds. Someone made the additional 12 seconds disappear. Or the Vox didn't trigger properly. I mean, I've used voice-activated recording a million times. I've used it for radio transmissions. I've done all sorts of work with that. I don't know what would have caused that, but I wonder if too loud of noise also didn't trigger it. That seems weird that it would be that case, but if she's yelling. I don't think somebody altered it. I think this is really just a system glitch, but it should be acknowledged.
Do you want us to turn down the volume so we get it right to the spot, or does the court care?
Or if you turn up the volume so we can hear if there's a pause.
Okay. And we're going to go to where the pause is. I think nothing to hear all that.
Well, just something preceding that lets us know that there is a pause.
Okay. So, if you can go.
Talking all the way up to it, and then boom, it stops.
Ma'am.
Right there. So I believe where that click was that we heard. And you hear click, and there's nothing, and then boom, you hear ma'am.
Okay.
So.
And where's the video that corresponds?
We're going to put it on. So at 3:49 in the recording, you click, and then boom, all of a sudden you hear ma'am.
Ma'am.
Yeah, that goes to the video. And you can hear her in there screaming, stop, stop, stop.
Hey!
And you hear some ma'am. And you can play so you as you can hear in the background, you hear her saying ma'am. You just pull the trigger. So go back one more time. So part of this is your screaming, stop.
Hold on now. Hey!
So that portion, 14 seconds, and it was a 2-second gap that appeared to have a click, and then just her coming back screaming, "Man, you don't hear any of the stop, stop, stop." And that was the concerns what we raised at bond motion, and the ADA that was handling it there. Once again, she was not as familiar with the case because Fowler just left, but that was one of the bases we brought up, that she agreed with us and told the judge. The judge watched it, listened to it, and then issued the bond.
Okay, so that was perhaps a bond issue. The court does find that the tape has not been altered. There has been a witness here that has said that what was presented was not altered. The court believes that witness's testimony. I'm not sure what you're trying to establish with respect to the video and the audio, but there has been an explanation that was read with a transcript where they're saying when there is no activity to be recorded or it doesn't rise to the level that it can be recorded, then there would be silence. And so the court finds that it has already been published to the jurors, and there was no objection at the time. The court finds that the objection at this time is untimely, but that there's not necessarily a foundation for the court to find that it shouldn't be republished to the jurors at this time. So it will be republished.
And if I could bring to the court's attention, from the testimony I wrote down that if it was altered or changed, it would have been somebody above her who had the custodian of it. And asked, would that be Tim White? And she said Tim White was her boss, would have been in that position. I do have Tim White under subpoena, and I guess we'll address it then.
Okay, all right. If you determine that you need to call Tim White, then certainly the court will allow you to do so.
Yes, sir.
Okay, thank you, Attorney Tucker. Okay, anything further that I need to address?
Nothing from the state, John.
Okay, anything further, Attorney Tucker?
Nothing from the state, John.
Okay, thank you. We can go ahead and bring the jurors in.
Is it possible that she hit the mute button and dropped her phone? Or dropped her phone and the phone muted, and then she picked it up from the ground in that moment? Is that a possible explanation? I did not hear the stop. She dropped it. Yeah, the driver who drove by said she was picking up a shell casing, but we know that's not true because there was only one shot fired and it remained in the chamber. She was not picking up a shell casing. I think she was picking up her phone. I think we heard the phone drop flat on the ground, bam, and that's the pop, the click that you hear, and then it muted. She picks up the phone again, okay? As the struggle continues, the shot's fired, she unmutes the phone and says, ma'am. That would take away what Mrs. Ari says, takes away the nefarious aspect of that. But my concern though is entirely, even if there's nothing on the tape that is, that changes the facts. Okay, I'm not saying that makes her innocent, makes her guilty. Nothing like that. My concern is the ADA has both these videos, and she knows that you can match up the beginning and the end of both of them, and there's a gap 14 seconds long, and she elicited testimony from a witness stating there was no gap. That's my concern, that they were not altered, that this is beginning to end, this is the call as it happened. That's my concern. And now she's saying, hey, it's too late. We already got testimony and saying it's not altered, so now you just have to deal with it. Yeah.
Okay.
So now we're gonna hear this tape again this morning because they've got the audio fixed. Remember, when they first played them, the audio was awful, right? Content warning, by the way. Somebody can put that up on screen. You're going to hear 911 calls that were placed during the commission of a crime or during the commission of a something that has been purported to be a crime, depending on how you view that. So just be alert, be aware that they might have some difficult things in here to listen to, and if that's not what you're here for, you might want to find another channel. Okay, Mrs. R.A. is talking.
Okay, so I'm just thinking this through on my way to go teach kids. What are the implications of this? Let's say that everything was all on the up and up. It was just an accident, some sort of glitch in the computer, the matrix is wrong. Okay, fine. Then what about those? What if she did say stop, stop, stop? How does that change things? Does that show that there was a struggle? Does it show that she was in danger? Like what does this change if we take out the whole where did it go?
Today,
I don't know if it does change things.
You look refreshed and ready to listen to the evidence.
It looks like you all followed my instructions and slept well over the weekend.
Proceed at this time to call its next witness.
State call Ashley Jackson.
All right. Not seeing Carla in the audience. I'm not sure if she made it in. Might change which charge she's convicted of. Yeah, if she's yelling "stop, stop, stop, stop" before the shooting, if we have, I'll tell you, I did not hear it in the video, and maybe it's because my hearing's bad, but that might influence the jury to think there's a lesser charge. This a hesitant witness. Karina, that's a possibility. Does this make reasonable doubt in the minds of the jury? Is that a poinsettia on the witness table?
All right, Ms. Jackson, are you able to remove your mask?
I am.
Thank you. Could you raise your right hand? Do you swear or affirm that the testimony that you will provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can have a seat and pull yourself up to the microphone. All right, will you please state and spell your name for the record?
It's Ashley Jackson, ASHLEY JACKSON.
And Ms. Jackson, are you a resident of Clayton County?
I am.
And how long have you been a resident of Clayton County?
All my life.
All right, and are you familiar with the area of Forest Parkway at the intersection of Riverdale Road?
I am.
Now, is that location in Clayton County?
It is.
And were you in the area of Forest Parkway and Riverdale Road on May 7, 2019?
I was.
And why were you in that area that day?
I was getting off work.
Okay, and about what time would that have been?
A little bit after 6 p.m.
Now, where do you work? Like, actually, where is it located? Where would you have been coming from that day?
Atlanta South Parkway.
And is that connected to Forest Parkway?
It is.
Now, can you explain what happened as you turned off of Atlanta South Parkway onto Forest Parkway on May 7, 2019?
I was getting off work. As I was approaching Forest Parkway, I was making a left off Atlanta South Parkway. As I was making my left and getting into the far right lane, Miss Hannah was coming up Forest Parkway. She was coming from the end off of Highway 85, and she almost ran me off the road. She was speeding. She was going very fast. When she almost ran me off the road, my coworker actually called me and was like, "That car almost ran you off the road." And I said, "Yeah, she's probably going to cause an accident." So I proceeded up Forest Parkway. She was weaving in and out of traffic. Once I got towards Riverdale Road, I saw Miss Payne had caused the accident.
Now, when you say she was weaving in and out of traffic, were you the only car that she almost ran off the road?
The right lane really didn't even have any cars in that lane, but she was still going like left, right, making other cars hit their brakes.
Now, as you got closer to Riverdale Road, when you said you saw that she caused an accident, can you explain to the jury what you actually saw?
As I got to Riverdale Road, traffic was everywhere. Well, traffic was stopped. It was just one of those days that it was just very busy. There was already something going on at the highway. People were out walking all over the place. And she had maneuvered her car in front of another vehicle and stopped them and caused the scene.
Now, do you recall if they actually collided at the point that you saw?
I don't really believe they actually collided. I'm not sure. I don't want to say something that I didn't see.
And once you saw the defendant's vehicle cornering the other vehicle, what did you, if anything, did you see her do?
I saw her at the driver's side door of the vehicle yelling obscenities for the man to get out the car. It looks like she was trying to fight him through the window.
And what was her demeanor at this time?
Very aggressive. Very aggressive.
And what made you kind of stop at that time?
Because she was yelling, "Get out of the car, MFer," like banging at him like this, like get out of the car. So it was the big scene.
Now, do you recall if the victim's window was up or down at that time?
I want to say his window was down. I can't recall if it was all the way down, but it was down. And she was like trying to fight him through the window.
And when you say she was trying to fight him through the window, what did you actually see?
I just saw her hands moving, you know, get out of the car, motherfucker, doing all this. I never saw anyone's hands come out of the window, per se, but I did see her at the window.
And could you see anything that the victim was doing inside of the vehicle at that time?
I couldn't see anything he was doing inside the vehicle. I never saw his hands come out of the vehicle from where I was.
Now, after you observed her hands moving and telling the victim to get out of the vehicle, what, if anything else, did you see?
Her pull a gun. After she pulled the gun, she shot him and she said, now you need an ambulance.
Now, when she pulled the gun, when did you hear the shot?
Immediately.
Now, were you able to observe any of the victim's demeanor during the entire incident?
No.
And do you see the person who shot the victim in the courtroom today?
I do.
Can you identify them by an article of clothing they are wearing and identify where they are sitting in the courtroom?
She's sitting directly in front of me wearing a blue shirt.
Let the record reflect that the witness has identified the defendant in open court.
The record will reflect.
Now, did you know the defendant prior to the incident?
No.
And did you know the victim prior to this incident?
No.
Now, after the victim was shot, what happened?
He kind of, he just laid back in his seat. His eyes went white. He just laid back. She stood back. I think everybody like ran towards her. I think I even came towards her and I was like, oh my God, you shot him. Somebody else waved down a police officer. He was already at the exit. The officer came running up. He said, what happened? Who shot? She tried to say that he grabbed her gun, but everyone immediately said, no, that's not true, because that's not true. The man never grabbed her gun. And he put her in handcuffs.
Now, what was the defendant's demeanor immediately after the victim was shot?
She had no remorse. She was just like, she was thugged out. She had no remorse at all. She was so right in that moment. She felt like she had done something.
Now, did you ever see the defendant attempt to render any aid to the victim?
Not at all.
It's the first time I've heard thugged out in court. Okay, this might get confrontational and repetitive, so expect some objections. We're up to 28 objections right now. I'm going to see if I can still get this to show. Let me switch, actually.
My name's Matt, I'm the attorney for this thing. I've got a few questions to ask. You stated that you were coming home from work. Is that an accurate diagram of where it occurred in front of you?
Yes.
Okay. Could you show me where you saw the accident happen and where you were positioned?
Okay, this will be interesting.
I was coming from this way.
Mm-hmm. And which way were you turning?
I was going to make, this is McDonald's, I was going to make a turn this way to go down Lisbon Road.
Okay. Had your...
So I saw the accident here. I ended up being back here. She was like right in here somewhere. It was right in here somewhere. So it was maybe one or two cars in front of me.
Okay. And so how far would you say you were from the accident?
I was literally right there. I had pulled my vehicle around another car so I could get a good glimpse because I was trying to record it, but it happened so fast I couldn't even record it.
A good glimpse.
You stated you were right there beside him on the left side of it, on the right side. Do you recall?
I wasn't right there beside them, but I was right there. I wouldn't say I was right there beside them.
Yes, ma'am.
Hey guys, give our mods some space here, but they're trying to. If you guys are making comments about mods need to do this, mods need to do that, they have to remove those comments as well because that adds to the problem. So just let them handle it here. He didn't ask to approach because he went to the clerk. Didn't approach the witness.
5, 6, and 7.
Now he has to approach.
These are pictures of the accident that have already been put into evidence.
Okay.
Okay, so as you see that, and where were you at in relation to that position?
I had to be probably back here a little bit somewhere. I had pulled my vehicle over this way so I could see.
Okay, and I'm gonna put one on the screen.
So I could see. That's twice she's mentioned that her view was obstructed.
Probably right up in here somewhere I pulled my vehicle. Oh, okay.
Would that other picture be a better picture? That shows more of the road.
My vehicle's over here somewhere by these white lines. I pulled my vehicle over here.
So this is around the corner from where she said that it occurred initially.
Okay, if you could, do you see on your screen?
Mm-hmm.
All right. You should have the capability to circle and a color will come up. Can you circle where you were?
Over in this area right here, over here.
Okay. So you were coming off of Riverdale Road or Forest Parkway?
It's coming off Forest Parkway.
Okay. And you see the diagram there that shows the roads. So you were behind them. You were behind the red truck.
I was one or two cars behind the red truck.
Okay.
When I saw the accident, I pulled over that way. I pulled my vehicle up this way so I could see traffic was stopped.
Okay, so when you pulled did you kind of pull on the sidewalk or to the side of it?
I pulled where I circled it. I pulled over that area.
Okay, so you were closer to the median.
I pulled right there where I circled it.
Okay, ma'am, if you look at the other picture up there, do you see a median?
I do see a median.
Okay.
So that's where I pulled it. I pulled over that way.
Okay.
So I could get a better look. I was trying to record, but I couldn't get my camera open fast enough because it happened so fast.
Okay. So you pulled over there. On the other side of the truck or the Jeep, was there any traffic or anything stopping anybody from going that angle?
Traffic was stopped. There was a traffic jam. There was something going on at the highway. Nobody was barely moving. It was a little traffic moving, but nobody was barely moving.
Okay. And you said that she was cutting in and out of traffic?
Coming up Forest Parkway.
Okay. And you said that she cut one of your co-workers off, and that co-worker...
No, she almost ran me off the road, and my co-worker was behind me, and she called me, and she said, dang, that car almost ran you off the road. And I said, yeah, she probably gonna cause an accident.
Okay, now, ma'am, do you recall having a meeting with the detectives on this matter?
I did come in for an interview.
Okay, and in that interview, do you recall speaking with the detectives?
Yep.
Okay.
Yep.
And in that interview, do you recall telling them about the incident as you just described right there?
Yes.
He's laid the trap.
And in this interview, to the best of your knowledge, do you recall telling them that he almost ran my coworker off and never once mentioned that he almost ran you off the road?
That's not true.
That's not true, okay.
I said she almost ran me off the road because that's what happened.
Yeah, the time for a call to come in, somebody call and talk about it, that's pretty quick. Yeah, he's going to try to impeach right here. He's getting evidence from the clerk, or I think he handed a note to the clerk that he needs back. Apparently, they're short on Post-it notes. She doesn't even look at it. She doesn't even want to look at it.
What I hold here is the transcripts of your interview with the detectives. If you could look at that to refresh your memory of what was said that day. And particularly what I'm asking, and you have, please take your time to look at whatever you want to in that, but I'm particularly looking at page number 3.
Page number 3?
Yes, ma'am.
Don't read it. Don't read it. Just read it to yourself.
And it's where Detective Chapman is saying, is she coming from behind you?
That's not what page 3 says.
Did you have more than one interview?
No.
With the detectives?
Did he mess up this impeachment? The assistant is more helpful than the first chair, but
Let me approach your honor.
You may.
he needs to talk louder or he's going to get an objection here.
Okay.
Okay.
Yeah, they're on page number.
If I could bring your attention to where it says, so she came from behind. I didn't even see her coming, okay?
Mm-hmm.
And then Detective Chapman says, sure. He said, one of my co-workers.
Oh, hold on a second, Attorney Tucker. You have to articulate.
Okay.
Because our court reporter.
You can't say mm-hmm. You need a yes or a no.
Okay.
Thank you.
And it says, one of my co-workers, she was pulling up behind me and she says, dang, that car almost ran me off the road. And you said, yeah, that crazy bitch is going to cause an accident. You recall saying that?
Yes.
Okay. Do you recall saying, and you can look to refresh your memory, that you said that she almost ran you off the road, or did you use the comment that your friend said, your coworker?
My coworker called me and she said, dang, that car almost ran you off the road. And I said, yes, that crazy bitch is gonna cause an accident.
Now, can you look at the statement I was saying right there where it says Ashley Jackson says, one of my coworkers, she was pulling up behind me and she called me and says, dang, that car almost ran her off the road. Not you, her. Is that correct?
I said what I said. I'm not sure why it says her, but when I said it, I was speaking in third person. Like, my coworkers calling me saying, dang, that car almost ran you off the road. So I'm not sure why it's typed that way.
So you're saying whoever listened to this audio of your interview inadvertently put her instead of you?
Could have been.
Okay. And you do recall saying, yeah, that crazy bitch is going to cause an accident?
Yes.
Okay. So at that time, you had decided because of her driving that she was a crazy bitch, correct?
Yes.
Okay. And
pretty much.
Okay. And you didn't know what was going on. You didn't know why she was driving that way. You just assessed that that's who she is based on that driving.
She was speeding up the road and she almost ran me off the road. So that's someone's natural reaction. So I'm not judging her per se because I don't know her, but that's someone's natural reaction when someone almost runs you off the road. You like, dang. So yes, that is my comment. That's what I said at the time.
Now you said there was traffic everywhere. Everybody was stopped and it was real slow, correct?
Once we got to Riverdale Road, it was stopped. But while we were traveling to Forest Parkway, the traffic was not stopped. We were still moving.
Okay. So it's fair to say that there were still cars moving and that cars could go around that accident either to the right or to the left, correct?
On Forest Parkway?
Yes, ma'am.
Once you got to Riverdale Road, you really couldn't go because there was traffic, so you had to wait.
So how is she weaving in and out and going past you if it was traffic stopped right up there?
So Atlanta South Parkway and Riverdale Road are a little ways from each other. So she was weaving through traffic going up Forest Parkway. Once we got to Riverdale Road, that's when traffic was stopped.
And could you show me on that diagram that's right there? You can stand up and show it, please.
What do you want me to show you?
Show you the direction of your travel and the direction of her travel.
We were coming from here, going towards here. This is where traffic was stopped because the highway is, I think this is the highway maybe? I'm not sure. Where the highway is, there was a incident. Like I said, the police officer was already on the scene. So traffic was very heavy here in this area. Nobody was really moving. But coming up Forest Parkway, we were able to move.
Okay. And so you're coming this direction, correct? Down that road, as you said.
Correct.
Okay. And the accident was where? You said was?
The accident was in here. The accident was in this area.
Okay. So, as you see that turn lane right there, he appears to be turning right on to Riverdale Road, correct?
That's correct.
Okay. And you're saying she came around and cut him off up there where he appears to be turning right, correct?
That's correct. You see how her vehicle
and you were turning left, correct?
I was going to turn left, but when I saw the incident, I got behind them because I wanted to see what was going on.
Okay. So you're behind them and you're saying you're at the meeting, correct?
So there was maybe one or two cars in front of me initially, but once I saw what was going on, I pulled my vehicle over because I wanted to see. I was trying to record.
All right. And what
I didn't know all that was going to happen.
What happened to the one or two cars that were in front of you?
They still were there. I moved my car out. Like I told you, I pulled my vehicle out so I could get a better view.
Okay, so using this picture here, can you show me where the one or two cars were positioned?
They were over that way.
Maybe if you could use the screen, you could mark
They
it.
were over this way. They were over here.
Okay.
I pulled my vehicle out.
So it's fair to say that where they were at, it was clear they could pull up there, or they could keep going past it, or get around that.
Nobody could go once she did that.
Excuse me?
Nobody could move in that lane once she did that.
Okay, in that lane. But was the area, you see where a walkway and all that area is it fair to say that that was clear they could have drove around the vehicles?
On the sidewalk?
Yes, ma'am.
Who was driving on the sidewalk?
I'm asking, is it possible they could have gone around the traffic, around that, on the sidewalk? Was it clear?
Who was driving on the sidewalk?
Ma'am, I'm asking you a question. I'm not here to answer.
I'm not going to say somebody was going to drive on the sidewalk. I'm not understanding why somebody would be driving on the sidewalk.
Clear question. Is it possible for somebody to have gone up on that sidewalk and drove around the accident? Whether you would do it or not, was it possible?
I'm not sure.
Okay.
Good answer.
And you said those two cars pulled over there.
Those two cars were, it was one or two cars over here. I pulled my car out at an angle so I could see.
And that would be at the kind of the top of the area.
Kind of where I circled it over here. That's where I pulled my car over in that area.
But on this, you're saying that they're turning right going upward, correct? Following that flow of the diagram.
What are you asking?
My name is According to your statement, you're saying they're coming this way, going this way, correct?
That's where the accident happened.
Okay, so they're going this way. And you say you pull over here at the median. And they're right there, correct?
Pull over this way, right over here, so I can record.
So right in this area here.
So wherever this is right here, I pulled right here.
Okay. And you said you got on the median, you went reaching for your phone, correct?
I was trying to fumble with my phone like this, but I could never get my recorder out. Get my camera to come on. It happened so fast.
And this is while you were talking to your coworker on the phone, correct?
Nope, I was talking to my coworker on the phone back on Forest Parkway when I first pulled out. When I got to this point, me and my coworker were not on the phone. I was trying to, I was looking, I was trying not to miss anything. I was trying to hurry up and get my camera to come on, but I could never get my camera to come on because it happened so fast.
All right, and do you recall looking down further where the Detective Chapman said, right? Would you have said the same thing? And you said, right. So there's no cars in this lane, but there's cars in this lane. Okay, which lane are you talking about?
So in the right lane on Forest Parkway, there were barely any cars, but in the left lane, like she could have just went up that lane, but like I said, there were cars in the left lane. She kept weaving through traffic. That's why I said that.
All right, so where she's parked right there, it appears she's come over into that lane, you say the right lane, correct?
Okay, so when I turned off of Atlanta South Parkway, it's further ways from Riverdale Road. So she didn't have to weave in and out of traffic. That's what I'm saying. She kept weaving in and out of traffic. There was no need for her to do that. She could have stayed in the right lane.
All right, and as you said, she's weaving in and out of traffic.
Yep.
Was she in that turn lane, or was she in the lane going straight?
She was out my sight by that time. By the time I got down to Riverdale Road, she had already caused a little accident and was out at his window. So that's when I saw her, when she was out at his window.
Okay, so you didn't see that maneuver or whatever they're saying. You didn't see the Jeep pull in front.
No, I didn't see how she maneuvered into and landed in front of him. I just knew that's what she did. By the time I got to Riverdale Road, she was already at his window, fighting him and doing all that.
So you don't know if another car caused her to go into that direction. You just presume, because she was a crazy bitch driver, that she did that, correct?
Nobody caused her to go into that vehicle.
But you said you didn't see it.
No, I didn't see it.
So why are you so certain that nobody caused her to do that?
Because nobody else was on the scene.
Okay.
Nobody else was in an accident. Nobody else was in an accident.
All right, so you're saying that the red truck hit her car?
It's not what I'm saying.
Okay, what are you saying?
She was, listen.
Look at the eye. She's giving the eye.
I don't know how they collided, so I never said anything about that. So I don't want to answer any questions about that because I never said how they collided. When I got to Riverdale Road, that was the scene.
Okay.
And I saw her at his driver's side window fighting him and cursing.
All right, so you never saw her exit the Jeep, and anything that occurred, you only saw her at the window, as you said, banging on the window or banging on the truck, correct?
She was banging at the window. I thought she was banging at the window at first, but then I realized she was like attacking him through the window.
Okay, and you said attacking him from the window. So the angle you have, if she's at the window, you can't see who's inside the truck, correct? Is that fair to say?
No, I could clearly see.
You could clearly see who's in the window at the angle you were at.
I could clearly see.
And you were in the driver's side of the vehicle that you pulled over in that meeting, correct?
Correct.
Okay, and from that angle, with her standing at the window, you could see who was in the vehicle and what was going on.
I could see her at the vehicle. Her arms were moving like this. Get out of the car, MF her. She pulled the gun out and shot him. I could clearly see.
And you are positive she was saying MF?
Very positive.
Okay. You wasn't saying anything else, but positive that the curse word you heard was MF?
Yes, she was saying get out of the car, and then she shot him, and then she said, now you need an ambulance.
All right, and you said that she shot him. How did she shoot him? Did you see the shot?
I saw her pull out the gun and shoot him.
So she pulled out a gun and pow, shot him?
Yes, in the midst of the situation she had going on, she pulled out the gun and shot him.
Okay, and she pulled out the gun. Was she outside the vehicle when she pulled out the gun?
Yes, she was at his driver's side door.
And then she shot outside the gun, outside the car or the truck?
Yeah.
Okay.
Yes.
So your testimony is that you pull up to the median, stop. From that angle, 2 cars are in front of you that move out of your way. So
those cars never moved out of my way. I pulled my car out to the side, like I said, to get a better view so I could record.
And you said the other 2 cars pulled over to the side, correct?
I never said those cars moved.
You just drew a line up there, man.
I said those cars were already right there. Okay. I never said those cars moved.
But they were in front of you at one point.
They were, and I pulled my car to the side.
Okay, so you pull your car to the side to see it. You're grabbing your phone trying to figure out how to record, correct?
That's correct.
And during this process of trying to figure out how to record, you're watching her and seeing the individual inside that truck.
I watched her the whole time. I was trying to like move my fingers by memory. I could never get my camera to open. It happened so fast.
Okay, but during that period of time, you're trying to get your phone to do a recording. You're looking.
Your Honor, asked and answered.
I'm
asked the same question multiple times, and she has answered the question.
Your response, Attorney
Your Honor, she has not given a definite answer of, and my question would be, if I could finish it.
No, finish your response.
Okay, I have not finished my question, Your Honor. I was going to talk about the face she said she thought she saw, and I was going to ask what was the demeanor of the individual inside the truck.
Okay, I'm going to sustain the objection. She has been asked, she's answered the same question several times. Now you can move on to your next question, but she has answered.
And I would respectfully request the court. I never asked what the demeanor of the driver's face was. She never answered that.
Next question.
Okay. What was the demeanor of the person inside the truck face?
I never really saw his face until afterwards. And so after she had shot him and everybody was out the car, everybody was trying to see if he was okay. That's the only time I really saw up close of his face.
We're at 2:27 now.
And then when you stated that you remember hearing her say a comment of, now you need an ambulance.
Correct.
Okay. Was that before or after she was on the phone with 911 requesting an ambulance?
I never saw her call 911 for an ambulance. When she shot him, she said, now you need an ambulance.
Okay, and so after she shot him, you said she walked away and did not pick up a phone?
She never walked away.
Okay, did she pick up a phone?
I don't recall her picking up a phone. And I never said that in my statement.
Ma'am, I'm asking you from your memory and seeing what you...
I don't recall her walking away and picking up a phone.
Okay. Do you recall her calling or talking or overhearing her say...
I do not recall her picking up a phone to call an ambulance.
So it's fair to say that when the incident occurred and everybody is stepping up to see what's going on as the congregation gets around the truck right there, you're telling me you didn't hear her make any other comments besides, now he needs an ambulance?
After she shot him, she said, now you need an ambulance. She was talking to him. She wasn't talking to, she was fighting with him. And she felt like she couldn't handle him the way she wanted to handle him, so she pulled out her gun.
I object
and she shot
her making comments of what she thought. That's speculation.
Okay.
Okay, so don't comment about what
So that's sustained.
thought.
You just want his
respond
third.
to his questions.
Okay. Now, you stated that in your testimony, if you want to go to page 7 to refresh your memory. And if you look below where Detective Chapman says, okay. Your comments were, she said nothing. The police officer finally came from the exit. And he was like, who shot who? Everybody's like, she shot him. And the first thing she said is, I didn't even have my finger on the trigger, but he reached for my gun, but I never saw his hands come out the window.
That's correct.
Okay. So you're stating that you overheard her say, I didn't have my finger on the trigger, but you're saying you never saw his hands come out the window, correct?
That's correct.
And she was outside the window shooting at him, correct? That's what you said?
That's correct.
And another guy was like, hey, I got it recorded, correct? You remember that?
Somebody did. I think somebody did say that.
Did you ever get to see that recording?
No.
And basically you were in the crowd that everybody was saying she shot him?
Yeah, when the police officer came up from the exit, he asked what happened. She tried to say that that she didn't pull the trigger. He was trying to pull her gun, but I never saw him do that.
Okay. And do you recall, if you can go to page 10, do you recall saying that she pulled that gun out and shot him immediately? And the detective said, sure, she was pissed. She was so pissed, like she was mad as hell.
That's correct.
Okay. So you're saying that she pulled the gun, pow, immediately shot.
She did.
And that's what you saw from the angle you were at right there at the median, correct?
Correct.
All right. Did you ever move your car from that median?
After the whole scene was over with, yes.
Okay. And where did you pull your car to?
I really can't remember.
And you stated on page 12 of your testimony to the detective, you said, I did see the gun outside the window when it was fired. The detective said, did you see the gun outside the window when it was fired? And you said, yes, I could see it. I could see her shooting the gun.
Yes.
Okay.
This is a problem because of the medical examiner's report. He was shot down by the belly button.
You said that thing you didn't see
back.
her shoot the gun.
It's not what I said.
In your testimony, we were having just a few, when the state was asking you a question, you don't recall saying that I didn't see her shoot the gun?
I saw her shoot the gun.
Okay.
And did you write a statement on that day?
I did.
I think when they say that she's a good witness, she's not letting him twist her words. Unfortunately, she has a couple different versions that she appears to have told relating to a couple key facts. He's about to put the statement up. Of course, he does not redact anything. The state wants to redact everything, so they're going to scribble on this this report. And the ADA is so frustrated that she has to do this. I will say that I recall her saying that she didn't see him shoot the gun earlier today, and now she's saying that she did. Maybe I heard wrong, but that was consistent with my memory as well. And her being outside the vehicle and shooting causes major problems for the medical examiner testimony, because one of them can't happen. Either the gun was inside the vehicle, or this guy was like
I may approach
pretzeled up against the ceiling of his car so his belly would be visible out the window and then turn towards the window as well. He'd have to be like practically scorpion shape. We've got some trouble there.
Does that appear to be a true and accurate representation of the document you wrote that day?
Yes.
Okay. Is that your signature there at the bottom?
Yes.
At this time, Your Honor, I'd like to tender Defense Exhibit number 38.
Any objection? No objection. I can see no objection.
And now, if I may approach.
Yes, you may.
Did you recall in this document ever saying that you saw her shoot him outside the car, outside the truck?
That's where she shot him at.
Okay. And you said that she jumped out screaming and punching the victim, correct?
Said she was outside of her car fighting the man at the window.
But in your statement to the police, you said she jumped out of her vehicle.
I said she jumped in front of the victim's vehicle causing the accident.
And then what does it say after that?
She jumped out screaming, punching the victim. She pulled a gun and shot him. She was not even remorseful.
Okay. Now, you stated earlier that you did not see her get out of that Jeep. You only saw her beside the window.
How else would she have gotten to the window if she didn't get out her car?
Ma'am, I'm asking the questions. Okay. I'm asking you a yes/no question. Did you see her get out of that Jeep and approach that window?
I don't recall seeing her get out of the Jeep. Once I got to Riverdale Road, she was already there. To my recollection. It's been some years.
But your recollection of the time it occurred when you wrote that statement, you said that she jumped out of the vehicle and ran up to the window and started punching.
I would assume she jumped out of the vehicle. I never said she ran up to the window. I said she jumped out screaming, punching the victim. She pulled out a gun and shot him.
Okay. So that's not a true and accurate statement because you didn't see her get out of the vehicle, correct?
Well, that would be the only way she could get out her vehicle is to get to his window. She had to get out her vehicle to get to his window.
Ma'am, I asked you. That is not a true and accurate statement, what you said, because you did not see her get out of the Jeep and approach the window, correct?
Objection, Your Honor.
There was no answer. There was a commentary without an answer. I don't mind her doing the commentary after she answers yes or no, but she never answered yes or no.
She answered that she did not see her get out of the vehicle. She answered the question.
Okay, I'm going to overrule the objection and allow Attorney Tucker to
He's on a roll. Two in a row.
So that is not an accurate statement you wrote because you did not see her get out of the Jeep and approach the truck, correct?
It is an accurate statement, but I don't remember seeing her per se get out of the vehicle. But she was at his window, punching and screaming.
How can you say it's an accurate statement when you didn't see her get out of the vehicle?
Because I was there, I saw what happened.
But your testimony said you didn't see her get out of the vehicle.
No, I didn't. I don't remember her getting out of the vehicle, per se.
But you wrote on your document for the police that you did.
Because this was in 2019, it's now 2023. So I really don't recall if I saw her get out of the vehicle. I don't remember every little thing that happened. This was in 2019.
Okay. Now, from that period of time, have you watched the TV media regarding this incident?
No.
Okay. Have you talked to anybody regarding this incident?
No.
You haven't talked to the state?
Well, of course. I thought you meant outside of the state.
Okay, when I say anybody, that would include the state.
Okay, so I have talked to the state.
Okay, and you did have an interview with the detectives too, correct?
That is correct.
Okay, do you recall when those interviews were?
Not too long ago.
Okay. And your statements that you were saying in your interview were different than what you were saying that day, correct?
So they're not different. What I saw is what happened. What I said is what happened.
Okay. And what you said is what happened on that document or what you told to the detectives?
Both.
Both. And there's no doubt in your mind, because it has been 3 or 4 years, correct?
Correct.
There's no doubt in your mind that she pulled the gun and immediately shot from outside the vehicle.
After she yelled for a little bit and screamed and tussled, she pulled the gun out and shot him.
And she was only yelling the MF, right? She wasn't saying any kind of cuss word. She was just yelling, "You MF."
She was yelling, "Get out of the car, motherfucker."
Okay.
Thank you, Attorney Tucker. Any redirects from the state?
Nothing further from the state, no.
Okay. May this witness be excused at this time?
She may.
Thank you.
Okay, so Ashley Jackson. I'm not going to fault a single witness, but
Does the
all
state
these
intend
witnesses.
to call another witness?
Your Honor, you can have 5 minutes to set up the technology to repurpose the audio.
Okay.
They're going to replay the calls and then they're going to rest. That's what they're going to do.
So, ladies and gentlemen, the state has requested some time to set up the equipment so that they can republish, and so I'm going to give you a short break. It is now 10:56. We'll resume at 10:50.
Oh. 19-minute break.
Sorry, 11:50.
Oh. It was reverse time. I knew what she was talking about. LNS, welcome to the gallery. Thank you very much. Okay, so here's what I want to point out just really quickly. The witnesses who have been testifying here. My phone's running. Hang on one second. The witnesses who've been testifying here have all exhibited something we expect, and that is they all tell the stories a little bit differently, and that's normal. Ivan, how are you doing this morning?
What a morning, huh?
I thought you were impersonating one jolly old elf when you started.
Yeah, well, hey, I'm on the nice list because
good.
Yesterday, listen.
Okay.
Yesterday, a man in a Santa hat came in, and I served him, and he was jolly, and so I think that puts me on the nice list, right? Like, I serve Santa, so like.
There you go.
I mean,
that should be worth some points. What's on your mind? There's been a lot of chat about the witness here, and about credibility. Is that what you wanted to talk about?
Well, I want to. First of all, if I had 3 employees like that last witness, I would never have to step foot in my store again. Everything would be taken care of. Okay, I wouldn't have to do a thing. I want to put her in charge of customer complaints tomorrow.
Listen.
But listen here, okay? I understand you read the sale wrong, okay? Like, learn how to read, okay? Yeah. Or whatever it would be. You know what I mean? But this is what I have to say. First of all, she makes a good point. This was 4 years ago, okay? 4 years ago. I don't know if anybody, like, I'm sure a lot of people here have been in car accidents and fast-moving, like, tragedies, and your mind sort of creates what you think you saw. Like, even it doesn't mean you're lying. It doesn't mean you're purposely trying to change what you saw happened, okay? It doesn't mean you're trying to get one over. It doesn't mean she has a bias. It certainly doesn't mean she's the R word, racist. It doesn't mean any of that, okay? It just means she's recalling what she has in her mind, okay? Yeah. Like, that's what she has no reason to lie. Okay?
This is what I'm getting at. This is what I'm getting at, though. Every witness that's described this incident has had some element of their story that does not match any other witness. Okay, and they're firmly holding to the fact that this is what I saw and this is true. And all of them have had something that doesn't match up with the video or the medical examiner. Sure. And in this case, the medical examiner won because she is the only witness who says firsthand that I watched her shoot him, that I saw the gun in her hand. I watched her draw, aim, fire, pull the trigger, and say, now you need an ambulance. She's the only one who said that.
Boy, oof, that's cold-blooded too, man. Like, if that was the dialogue.
If that's what happened, that's malice murder. That's boom.
That's as cold-blooded as it gets. I put in chat, one time I saw a guy get his arm broken for a debt that he owed, and the guy who broke his arm says, looks like you need a doctor, and threw a phone book at him. And that's what it reminded me of. That's as cold as it gets.
Yeah, that's pretty bad.
the other thing I will say is, what is her reason for lying? Like, she has nothing to gain. Like, she has nothing. You know, the fog of war is real, okay?
Yeah.
How many people in chat can honestly say, aside from an accident, they've seen somebody get shot point blank? Okay, when that happens, like, everything sort of stops, but it's also moving at 100 miles an hour. It's the weirdest thing you can ever explain, and I know I did a poor job of articulating that, but I know we have some veterans in the chat. I know we have some people who've been in situations like that. Everything sort of stops in slow motion, but your brain is going 500 miles than it ever has in your life. And so you're trying to create something that makes sense out of something that doesn't make any sense. Okay, so your brain is sort of working
It's trying to
against
process
itself.
and make sense of something that's, it's like, I can't compute,
Right.
make these facts work, right? So your brain's
Yeah,
like trying to find, to catch its other arm.
Absolutely. This crazy thing that just happened, it can't be the way I saw it, so it has to be this way. And the brain will do that. Like, it's happened to me a dozen times or more, like where I've seen something happen, like, this isn't normal human behavior, this isn't normal human interaction, this isn't normal day-to-day stuff. And so your brain just starts creating, I'm not going to say creating facts, but creating facts that are more easy or more palpable for your brain to sort of digest.
So
that's a real thing.
Ivan, what happens when those facts that your brain creates don't match up with the evidence, the firm physical evidence that can be measured, counted, weighed, observed? What then do we do with those facts?
Hey, well, you know what? That's up to the jury to decide if it's intentional or if it's just, like I said, a casualty of the event. Okay? And so you can't just say, oh, they impeached her because it's not 100% the way it was 4 years ago when she witnessed something that was terrible and awful and tragic. That's not how that works. You just say, you know what? This woman is putting it together the best way she knows how 4 years later, and this is what she recalls. It doesn't mean, you know.
The problem is, yes, 4 years later, but the story has changed a lot, and there were, I think, 3 or 4 points that the lawyer brought out that changed, that had reversed, that her involvement was now in a different role, her position, what she had seen, and I'm not faulting her for saying, yeah, she jumped out of the car and started doing this and not seeing that. Yet no one's expecting the driver of the vehicle, Hannah, to teleport, like you mentioned, to the car.
Yeah.
Okay. Your brain like bridges the gap sometimes, and that's fine.
That's why that's splitting hairs by the DA. Well, you didn't say you saw her get to the car. Well, how do you think she got there? Okay, like, can we at least make some, like, you always say, reasonable inferences? Like, how do you think she got there? Of course she went to the car. Of course she got out of her car to get to her car,
right,
to do what she did.
And the attorney was not saying that she didn't do that she didn't jump out and run over there. But the attorney's saying, how can you say that?
Because I have a brain and I realize people need to get from point A to point B. And,
how can you say I couldn't see because there were cars in the way, but also describe what you couldn't see? That's what he's trying to draw out.
A reasonable inference. That's how.
Okay, but if that's what you're doing, if you're making reasonable inferences, then you're guessing, right? It's probably a really dang good guess. It's a dang good guess, but you're guessing at what happened, and then what else are you guessing at? Is she guessing that she draw the gun and shot him immediately?
Guessing people got from point A to point B is not guessing that the gun went off.
Right, but she guessed. Apparently, she guessed how the gun went off because it doesn't match up what the ME says. How can you get a shot straight forward as he's sitting in the driver's seat, straight forward, belly button level, which is below the height of the door, and have her outside drawing and shooting horizontally across the car, and have it go back to, tummy to back on him next to his belly, from the right to the left?
Well, I think that like these are all like hot points for like, addicts like us of the true crime world. But what I don't think is going to matter, I don't think any of this is going to matter to the jury, because I think the jury is, whether this is lawful, whether it's right, whether it matches jury instructions, etc. I think they are not going to be able to look past that she decided to go into Annie Oakley mode and do the thing that she did to begin with. I don't think any of the residuals that happened after the fact are going to meet anything. Like Zen Dreaming just said, it's totally splitting hairs. Yeah. Like, I think they're only going to look at the fact that she didn't have to do what she had to do in the first place, and then she took it a step farther and went commando, and now somebody's dead. I think that's all that the jury is going to look at. because whether that's right or wrong, I don't know. But I think that's how it's going to play out.
Ivan, great point. I've got another call coming in that they've been very patient. Yep. Let me see if I can take it. Thank you very much, sir. We'll see you.
Love you guys.
Bye.
Bye.
Oh, I just barely missed it. Call back one more time. Midwest, call back one more time. This was I don't know. It's interesting. I think Ivan's right. There's a big part of this case that just seems. I think this is it. Let's see if this is them.
Call from Midwest Trans Health.
Hello, who's on the phone?
Oh, hello. This is Maya.
Maya.
I am from Pennsylvania. I thought I would give a little perspective from a Black person. I don't know how, I don't know what the makeup of your chat tends to be, but I have noticed that some people...
It's just people who like true crime. That's pretty much all we have.
Right.
But
I noticed... yeah, sorry, go ahead.
No, so you're giving a perspective as far as mannerisms of the witness? Is that what you're talking about?
Yeah. And I think some people are kind of getting at that, that they seem to have an attitude, or like she's averting her eyes, like picking at her nails, like that sort of thing. I
didn't see that. I didn't see the attitude. I saw her defending her stance and saying, no, don't attack me. I said what I said. That's what it is.
Exactly.
I would say that I also believe that this witness doesn't have any reason to lie about anything. I don't think that she thinks she's lying. I don't think she's up there saying, what can I say to make it look like Hannah's guilty? I don't think that's even crossed her mind. I think that she is on edge because this attorney's coming at her, okay, and, asking the same question, and she's answering it, or at least she feels like she's answered it thoroughly, and he's like, well, you're going to answer it. I'm trying a different angle. And so any defensiveness we saw out of her was from the hostility she felt from the defense attorney, because he does get a little bit up in her face, a little bit verbally.
Right.
Any other thoughts about that?
Yeah, I think that for me, it's just the way that people may describe her mannerisms. When people say, anytime someone says a Black woman has an attitude, I kind of get an itch, because as a young person, I was told that I look angry or that I have an attitude, and really I just had generalized anxiety. So I think it's a good thing for us to be conscious of when we are talking about the mannerisms of Black people in particular, that we're socialized to think of Black people, especially Black women, as angry and aggressive and having an attitude. And she may have been having an attitude, but I think, like you said, a more accurate term to describe her would be that she's feeling defensive.
Yeah, and she gets passionate about saying this because you're questioning her. She's like, look, I told you. I wrote it down. I told the detectives. I've told you. Now you're trying to twist into something it's not. That she just gets a little, involved in that way. Thank you very much, Maya, for the feedback on that and the input. I really appreciate that.
Yeah, absolutely. Thank you.
Yep, wonderful. We'll catch you again. We'll see you.
Okay.
Bye. I will also say I love that witness just for the exchanges, the back and forth, where she's like, listen, let me tell you how things are, which is funny. Amber, I pushed the button, but I never have to. Amber, how do you get through my call screener, first of all?
It's magic.
You're the only person who can call the burner phone, and I answer, and it doesn't give me the chance to pre-hear the message and see who it is before I let you in.
It's because I'm super special.
You are. What's on your mind?
I'm gonna pull the mod card real quick.
Yeah.
Please be mindful that if you have an opinion that differs from somebody else's, that does not mean that they are being disrespectful. It does not mean that they are attacking any one person. We are allowed to agree to disagree and have differing opinions. Scott has set this channel up to be an inclusive space where we can respectfully agree to disagree. There's a lot of chatter back and forth in the chat about somebody else's opinion, which differs from their own, means that they're being disrespectful. They're being
Yeah, they can have different opinions without being disrespectful. And we would ask that all the opinions are be shared in a respectful manner. Just be nice to people. Like, don't call somebody names, whether it's a witness, whether it's somebody else in chat, whether it's anybody else. You know, no name calling is the first thing. And if you've got a different opinion, share it and tell us why, and help us learn. I may be wrong. I've been wrong before, right, Amber? Have I ever been wrong on this channel? Have I ever?
Plenty of times.
Usually at least once a day. But
just one.
Amber,
just once
you're breaking up. You're breaking up. Yeah, and let me. I've got another call coming in. We're going to try to take, but let me also say, if you do see somebody in chat that's not following the rules, just let the mods handle it. Because if you jump in to call it out, we also have to delete all those because they escalate. So jumping in to point the finger causes more problems. So just leave it for the mods. I know sometimes they get a little backed up. They'll catch up and we'll get it taken care of. But thank you very much, and Amber, thank you as well.
Absolutely. See you in chat.
All right. Bye. All right. Let's see. All right. We have be excellent to each other. Thank you, Kurt. Politeness is always good. That's it. That's it. Just be polite. Chances are about a third of you will disagree with anything I say. That's on a good day. On a good day, I can find something we can agree. About 2/3 of us can agree on something, and it's all right that we disagree. And on this one, especially where we're looking at this as the jury may look at this, we have the right to look at this and weigh the evidence and say, well, this one doesn't ring true to me, or this one really resonated. You know, I like what I heard there. Let's see. I'll have to bring out my dad voice. Not this early in the morning. No, not this early in the morning. Yeah, always throw in my opinion. That helps. Let's see. We've got another call coming in. Let's see who this is. Trying.
Call from
Fat Yoga.
Hello, are you there?
Yeah.
Hey, this Recovery Addict. Who am I speaking with? Is it Pat?
Fat Yoga.
Oh,
yeah.
Fat Yoga. Okay, welcome.
Okay. So I just wanted to say I was really impressed with this last witness. And I really loved the comment before about like how people see black women as angry. And she, this witness was just trying to do the best she could and feel like she was, able to contribute. And so I think that the defense attorney is trying so hard to attack everybody's statements that he's really digging himself a hole.
Yeah, I think there are probably very few jurors who look at him and say, he's the guy I want to hang out with this weekend. Because he's really just come across as mean to pretty much everybody. And I realize he's got a job, right? Somebody has to do that job. Somebody has to do the defense. And Hannah Payne deserves, as entitled to a good, solid, attempt at defense, a qualified, attorney that can do the best that he can in her case. And I think that's what he's doing. Right. But he sure doesn't try to be nice at the same time.
No, and I think that, we've all, as, law nerds, or, we've all seen trials where the defense attorney, even though they have a job to do, they don't do it in a way that is, I think, repulsive. Yeah. And he just is attacking every single witness. And it just really, I don't think that it's doing him any favors at all with the jury.
Yeah, it seems like some of his attacks are almost fishing expeditions as well, like hoping to get a response that might help out, instead of focusing on those things where he might have some traction. And,
Yeah.
And that, I think that that goes to add to overall, conclusion the jury might have of him, that he's fishing for everything. He's just looking for some loophole somewhere.
Well, I appreciate you listening to me. I just wanted to say that I was really impressed with her. I thought she was. I think that she was just defending her position, and we all have to give a little grace to everybody.
Yep.
So I appreciate
totally
you talking to me.
Thank you so much. We'll see you. Bye.
Bye.
I will say, remember right when the witness came in, I think she looked hesitant, and I think she looked hesitant because the state, the prosecution probably prepped her and said, hey, just so you know, he's going to come at you, right? He's going to ask you a bunch of questions, and he's going to spin it, and he's going to be like, well, what you said this, what this, and how does that match up with this detail? And so I think she was a little guarded from the get-go, even from the moment she stepped into the courtroom, for that reason. Bite Me says, Buttercup says, hello to everyone. We're so glad to be here. Life wouldn't be the same without you, Scott. Thank you, Bite Me and Buttercup. Rebecca, it's good to have you here. An eye for an eye makes the whole world blind. I like that one. Okay, we have exactly 0 minutes until we're supposed to be live again. What I expect right now in the trial is that the prosecution is going to replay, and I think I hear the judge walking down the hall right now. Yep, I can hear her walking down the hall. There she is. Okay, I've got really good ears. The prosecution is going to replay the 911 calls that were played before, but the audio was poor. They fixed the IT. We're going to listen to those again. It's very important what we hear. We've got to listen very carefully. And then, sorry, I'm going to have to... Hang on one second.
Johnny Stradler.
Johnny, judge is back. We got like 3 seconds?
Real quick.
Yeah.
The point is, the witnesses saw her. Mm-hmm. The witnesses, she had a gun, and there was an altercation. There's no justification for bringing a gun to a traffic accident. They just need to place her and the gun at the scene. That's what's the bottom line on the whole thing.
I have a little bit different view on it because she was licensed to carry, which means no matter where she is, as long as she's not in the federal building, she has legal right to bring the firearm. That's a state law.
Not a problem that she can have the gun. What I'm saying is, at one point, where is she in fear for her life that she's going to be actual fear for her life that she needed to draw the weapon? She can carry one.
True.
But there wasn't a reason to draw it.
I agree. I haven't heard any testimony. Maybe we'll hear something from the defense, but I haven't heard any testimony that would indicate that she might need to use that sort of defense.
She'd have to be in fear for her life to use a weapon.
Unless it was what happened when her shirt got ripped. And maybe that's... if she was standing beside the car and he grabs her and pulls her in the same time he starts accelerating, now she's attached to a moving vehicle, or he's trying to free himself. Maybe that.
Then it would be a safety concern. Sure.
Yeah, I've seen police officers fire in that situation.
Correct. I agree with 1,000% under that. Yeah. So we got to find out that part. But as far as the witnesses, as long as they can place her there, that's the bottom line. What the DA is trying to do is place her there. And in the situation, and but I thought the witnesses so far, this last one was pretty good.
Yeah, they've been able to place them. I think they've got a little more work to do than that. That doesn't, for me, that doesn't get beyond the reasonable doubt. But appreciate the call. Thank you so much. I think Judge is about to start talking here.
Bye.
Bye. All right, hang on one second here.
Be seated.
There's the judge.
The court always appreciates the timeliness with which you respond to the time frames put in place. You may recall that at the beginning of the state's evidence that the 911 tapes were published, but the volume was low, and so the clarity was affected. And so the state has made a motion to republish those 911 tapes. And so I have granted the motion, and they're going to do that at this time.
They're probably going to rest right after this.
Yes.
The record will be publishing States Exhibit 3 for Terry Robinson's 911 calls, States Exhibit 4.
Ready for an objection?
The defendant's 911 calls, and States Exhibit 6, Tiana McCrae's 911 calls.
Okay, thank you. Is there an objection?
I would raise the objection we had at the bench, but understand the court.
Right, so the court has ruled and has allowed the state to republish.
The first 911 call that we will republish will be Terry Robinson's.
This is Terry Robinson's 911 call. That's the first one. You should be.
Hey, this is an accident up here by Clock House and Forest Parkway. Clock House and Forest Parkway. It's a truck, unfortunately, hit a vehicle. And I'm looking at the guy now, he's pretty good, he's moving and everything. But we got a truck that had an incident with a vehicle. Farmhouse and Forest Parkway.
What kind of truck is it?
It's a semi-tractor trailer and it's a pickup truck.
A red Dakota?
Yeah, red Dakota.
Okay, does it say that you want to start it in dirt?
But you need assistance? You can handle that? Sir. This old thing. You do the ambulance system? He's not saying anything. So you okay? Yeah. All right. Sir, do you need assistance? You need ambulance, okay? Well, I mean, you with this, well, are you okay?
We have police camera for this.
Yes, I'm aware. I'm a state officer. I work for GDC. So, yeah, that's 540.
Is any airbags?
She was there. She was there. Nah, I'm
sorry?
No, man, I'm talking to the gentleman who drives the tractor trailer truck. And he was the car swerving in. You know what happened. He fell asleep. But you need to be here today. Don't start it. Don't start it because you're smoking. Sir, this spot, right there, right there.
Are they obstructing the roadway?
I saw from the I saw the car coming. And then I see the light was green. Yes, you had it for you.
Okay, sir.
Yes.
Okay?
Yes, ma'am. We'll apologize for that, ma'am.
No, that's okay. Thank you.
Okay.
That was the first accident when he hit the semi truck.
Clinton County 911. What is the location of your emergency?
Clark Howell and Forest Parkway. We had a call earlier, and it's been over like 20 minutes now, and no police or no ambulance have shown up at this location. And like I said, it's involved a red Dakota and a semi-tractor truck, and none has showed up at this moment in time.
Okay, I just got a call. We already have someone on the way.
The reason why I'm asking that because the driver who caused the accident, I think he's impaired. Something's going on with him. And so the thing about we're trying to tell him to turn his vehicle off from the smoke, and he's not following the command. So that's why I'm asking to see what if he's moving his ears. He's going to drive off, man. He's driving off. He's driving off. Take a picture of the driver light. Take a picture quick. He's driving off. He's driving off.
Where's he going towards?
Yeah, he's heading towards Riverdale Road. Upper Riverdale Road. That's where he's headed.
What kind of vehicle is it? Is
He's
that
in
the
the red
red Dakota?
Dakota. Get out the road, sir. Get out the road. Hurry up.
What's the tag number?
Red Dakota, front end damage to his red Dakota. Did you get a picture of the driver light? The tag. Oh man, let's get out the road. Get out the road. He's headed towards Riverdale Road, heading towards 285 area. Riverdale Road. He's heading west on Forest Parkway towards the area.
Give me one
Okay, good. Go. Now the other driver who was and she's going to take a picture of the yeah, he's flatting. He's an African American. Two vehicles. His vehicle and the truck. The truck is still here. The driver of the truck is still here. And sir, step out the road. Just step out the road, please. So he's in a red Dakota. It's a 96 model, give or take 97 model. He's an older black gentleman, gray hair, blue shirt on, and front end damage. Heavily front end damage in front. Heavily front end. I knew he was going to do something. If I was in uniform, I would have picked a T, but I didn't. So,
Okay. So
he's heading toward that area. If we get a police up that way, I knew traffic. I knew there was an incident up that way. Hopefully, that there's another officers on that see him.
give me one moment.
I know it's RH8 RHA 5933. Very well. RHA 5933. RHA 5933.
I got it. Robert Henry Adams 5933.
Yes. It's okay. She got it. She got it. It's all good. Yeah. Hopefully the lady in the Jeep was almost in the residence, so she turned around and she went after him. So she's gonna take a picture of his vehicle and stuff. Can't you believe it? I knew he was something wrong with it, guy. I knew it. God. This is crazy. Yeah. Well, you're not gonna get far. This truck gonna overheat. This truck is gonna overheat. Okay, ma'am, you have my number. If anything, y'all can hit me back. But I'm here with the driver of the truck, the semi truck, and everything. So my number, you have it.
Okay.
Thank you, ma'am.
Thank you.
All right.
The state will now republish the defendant's 911 calls, which were state's exhibits 4.
Payne County 911. What is the location of your emergency?
Yes, ma'am. I'm actually on Forest Parkway and Clark Howell Highway. And there was just an accident. I'm sure they've already called, but I just witnessed it, and I just wanted to make sure that I guess called the police as well in case they didn't.
All right. Were they what were the kind of vehicles involved?
It's a red Dodge pickup truck. I think it's a Dakota. And a semi was involved. And the red Dakota ran the red light and slammed into the side of the semi.
It doesn't look like we received any reports on it yet. I'll go ahead and put in a call here.
Okay.
Red Dakota. And were they on Forest Parkway or on Clark Howell?
The semi and I were turning left onto Forest Parkway, and the Dakota was going west on Forest Parkway.
Oh, okay. And what's your name?
My name is Hannah, Hannah. Last name is Payne, Payne.
And what's your callback number?
470-512-1847.
We appreciate you calling this in. We'll get someone out there and try to assist them.
Okay, thank you.
Thank you. Bye-bye.
Payne County 911, what's the location of your emergency? Yes, ma'am. I'm on Clark Howell and Forest Parkway, the intersection. I actually called about 20 minutes ago for an accident, and no one has shown up yet. But I am under the impression that the guy that caused the accident, who ran the red light, is drunk, and he's gotten back in his car, and he's looking like he's trying to drive away. Okay, can you get his tag number? Hold on, he's driving away. It's a red Dodge Dakota. Give me 1 second, hold on. Okay, so he is going west, down Clark Howell, down Forest Parkway. Okay, so you couldn't get a tag number? No, but I'm catching up to him right now. Okay, ma'am, we actually do not want you to chase him. We just want you to be safe. And it's I understand. Not to chase him. I understand 100%. I'm just going to get the tag number, if nothing else. But I am going west down Forest Parkway.
See,
Yeah.
this is Hannah calling. This is the defendant's voice.
I mean, his radiator is busted and everything. So I honestly have no idea how he's driving the truck the way that it is. Okay. It is a Georgia Tag. License plate is RHA as in apple 4859.
Okay. So if you can go back to that location where the incident happened, it's because someone is actually on the way to you guys now.
Okay, well, there's a police officer there, but he is drunk. I'm sorry, but I'm here to tell you I'm not going to follow him. Because he is going to cause another accident. So I will stay behind him until an officer can get to us. But until then, I'm not moving.
Yeah, no, that's what I want. I want you guys to go back to the location where it happened, and an officer will be out there momentarily, okay? Ma'am. Ma'am. Yes.
Ma'am, he just pulled the trigger of my gun in my hand while he was.
Ma'am, you were not supposed to follow him.
He hit my car.
Okay, you got the tag number.
There's a police officer down the street. Tell them to come up here now. He pulled the trigger on my gun after he attacked me. Tell the police officers to turn around from the 285 entrance and come up here immediately. And now he needs paramedics. I'm safe, but he ain't. Can you say? You say what happened?
And now he needs paramedics, is what I heard.
Okay, ma'am, where are you guys located now? Ma'am.
I don't know. I did.
There's the I did.
No, I don't.
Okay, ma'am.
There's a police officer here now.
Okay, speak with them.
All right.
Does she take the stand?
They will now republish State's Exhibit 6, which is Tiana McCraney's 911 call.
Clayton County 911 was connected.
It's a call
check with the transfer. Hold on, sweetheart. Call it about Forest Parkway and Riverdale Road.
Yes, I got him.
Okay.
Hello?
Hello?
Hi. I'm sorry. I'm on the intersection of Phoenix Boulevard and Riverdale, right before the highway. Is this woman? Okay. So, sorry, they got it was like a merging lane, and then it was a merging lane, and then she like got impatient and went around him for no reason because it was coming traffic, and then he almost hit her because he did that, so he braked suddenly, but But then she got mad and hopped out her car, and then she pulled out her gun and started screaming at him. And he was like, "What the heck?" And then she was like, "I will shoot you," and she started hitting him. Yes.
Okay, and where are you guys?
We're right by the exit of 285 West and 285 North, and it's like Phoenix Boulevard goes one way.
Okay, yeah, I have somebody on the line for that. Okay, ma'am.
Okay, thank you.
I'm curious if she takes a stand, is there anything she could say that would change your mind if you feel she's guilty right now? I think they're about ready to rest.
Hello?
Yes, ma'am. Are you still there?
Sorry, yes, I'm still here.
Okay, you said she pulled out a gun.
Yes.
Did she shoot the gun?
We heard a gunshot, and then one guy got out his car, and he was like, "Yo, we need an ambulance." Now I'm blocked in. The guy was like, "We need an ambulance." I don't know if she shot him or not. Sorry, dude. And now, did she shot him? She shot him. What?
What type of vehicle were they in?
She's getting locked up. He was in like a. Hold on. Let me get out. It's like a brown pickup. It's a small Dakota.
Okay.
And she's in a Jeep.
Okay, we have someone in with us. Okay.
They're there already. But okay.
Thank you.
All right. Thank you.
That is all we have, Your Honor. Okay. Thank you.
I think we're going to take a break. Are they going to rest officially?
Does the state have any other witnesses that it intends to call?
No, Your Honor, the state rests.
Okay. State rests now.
Okay. So the state has rested, meaning that all the evidence that they intend to adduce in this case has been presented to you at this time. And so there are things that I need to take up with defense counsel and the state at this time. And so I'm going to excuse you at this time. I think it's an appropriate time to take a lunch break. It is now approximately 11:40. I'm going to give an extended lunch because there are things that the court has to do with both the state and defense attorney at this time. And so I'm going to instruct you to be back at 1:45 this afternoon. So you're excused. Have a good lunch.
Okay, so I think there's a couple things they need to do. First, they need to find out if she's going to testify. I think right now the defense should file motions for directed verdict, if nothing else, to preserve the issue for appeal. I think, I know you guys disagree, but I think she has to testify. I mean, she doesn't. It's generally a bad idea, but if every witness who's testified so far has something, a key element of their testimony that's disagreed with, whether it's the audio recordings we've heard or the video recordings we've seen or the medical examiner's testimony. Every single witness has issues with that. If she gets up and testifies and tells a story that fits all the evidence perfectly, where all the pieces fit perfectly in place, does that give her credibility over what the people who testified against her?
I request a louder to get she's over here. I hadn't heard that. We may take a brief 3-4 minute break.
And we can Attorney Tucker, but I think that any motion you're going to make, you would probably just make now and then we'll take a break. Yes. Because I don't expect that your motion will be extended.
Yes, ma'am. You join me in the motion?
Yes.
At this time, Your Honor, I would make a motion for directed verdict based on the facts that have been presented here, based on the evidence that we've heard so far. I would, and I'll go through each charge one at a time, and then that's okay with the court.
Okay.
At this time, Your Honor, I would make a motion to direct the verdict that the state has not carried the heavy burden of proving beyond a reasonable doubt of the offense malice murder, as they've stated in their allegation that Hannah Payne did on May 7, 2019, with malice aforethought, caused the death of Kenneth Herring, a human being, by shooting him with a firearm. The evidence we've heard are contradicting testimony of what's going on. We've heard one witness say that she came out and held him at gunpoint. We had one witness come out and say she jumped in the window. We had one witness come out and say the accident happened somewhere else besides where the other two. They said that disputed testimony. Some say the gun was holstered until the car hit her car. Some say she came out with it pulled. We heard testimony from the forensic examiner who said the angle of the bullet in the entrance was a slight right to left, which the theory that was shot outside the vehicle, and we saw the video, that is not a correct account of what happened. In the video, we heard testimony saying that they were fighting over the gun, going back and forth. And then upon the gun going off, immediately she picks up the phone and requests assistance from the police and an ambulance. She's not a nurse, she's not a doctor, but she does the best thing she could. She explains to 911 what happened and requests assistance for him, for Mr. Herring. So in no way or form has anybody come in and proven there was malice of any. There was no malice, no testimony of her saying, you know what, today this guy caused an accident, I'm going to take his life. There's no testimony, there's no evidence that even gives an inclination that that is what was going on. And even though you have people say, oh, she had no remorse or whatnot, she was still on the phone attempting to get an ambulance to come there. She stood and she argued or explained to the bystanders she didn't have her finger on the trigger. This was not anything that had intent. This was a situation where she got grabbed, she was being pulled, and she pulled the gun to defend, and then he grabbed it and the gun went off. And from her on the 911s, her statements on the 911s, that he went off based on him grabbing the gun and his finger pulling the trigger. There's no malice that has been established in any form or fashion to constitute or even prove anywhere near a reasonable doubt that she did do malice murder. And should the court see and review the testimony the way I have, then that would basically take out the malice murder and the gun charge that was with it, count 6. Then I move to count 2, felony murder, where it says that on the 7th of May 2019, while on the commission of aggravated assault as alleged, a felony that caused the death of Kenneth Herring, a human being, the testimony was that, once again disputed, you don't know if the gun was on her hip or the gun was pulled or what to believe, but based on the video and the testimony from Mr. Williams, who had the video, who the video kind of corroborated exactly what he said, that the gun was never pulled until after the struggle was ensuing. and that the individual other accounts were that the vehicle had stopped and not hit her vehicle, but then did accelerate and hit her vehicle. And no one was able to give an account of the position of her, whether she was on the side of the car, whether she was on front of the car. We did hear somebody say it was like an inch, but anybody who would say it was like an inch would have said the car's hit. So I'm not sure how we can use the weight of that testimony, because it doesn't appear to be possible or logical. The gun was not pulled until after she is screaming stop. They're going back and forth the struggle. You saw pictures of her shirt ripped. You saw the pictures of the scratches all on her neck, her arms. You saw the swollen wrist. All of these show that there was a struggle ensued. And the testimony, they said that she was hitting him or punching him. There were no bruises. From the forensic examiner, she said there were no bruises or contusions or anything on his body except for a pin-sized bruise on his left shoulder where the seatbelt would go. But it was not the size of a seatbelt, but a pin-top size. Therefore, to pull the gun, she had to use for self-defense, as he was continuously grabbing, pulling, and revving up his car and driving. And in the 911 tape, at one point she starts screaming. You hear the revving of the vehicle, which confirmed that the revving of the vehicle was to drive off or to hit, or I'm not sure what his intentions were, but from a reasonable person's view who comes up with a phone to say, here, I have the police on the phone, it's not reasonable for somebody to rev up the engine or grab her or try to ram her or her vehicle. She stated in the 911 call, he just hit my car. And luckily it was her car and not her. So as for the aggravated assault upon him grabbing and suing, you saw pictures that were in the truck. A lot of people didn't hear what was being said from inside the truck, but there was a lot of instruments in there that could have been used for serious immediate bodily harm. There was a knife, there was a small saw, there were needles all over the place. All of these could have been used to cause immediate harm to my client, and she was only able to pull a gun to try to deter him from continuing with the actions he was doing. And she stated she never had her finger in the trigger. Therefore, it was never an intent to pull a gun and shoot. It was for protection and to deter him from his actions there. And therefore, because the aggravated assault has not been proven beyond a reasonable doubt, the felony murder in count 2 should not survive the directed verdict based on the facts that it has not given rise beyond a reasonable doubt that the aggravated assault occurred in the manner it was accused, to make an assault upon the person of Kenneth Herring. It was pulled as protection and to deter him from continuing his actions that he had continuously did, even though you heard her screaming, stop, stop, stop. And therefore, if the court sees it, and I presume they will, sees count 2 and count 3 would be resolved with the directed verdict, and that would take out the count 7 of the commission of the possession of a firearm during the commission of a felony. And I would bring the court's attention to count 4, where they said the felony murder with the underlining felony being false imprisonment. The state has put testimony up there that said the car was going, she pulled in, you saw the angle. 2 of them said that it stopped in front of him, that he had space. One says like an inch, one says not sure how much the space is, one didn't really have an angle to see it. But they all confirm that there was not a collision, that the car was there. And as we saw from the pictures that were tendered, there was plenty of room to move or to go to one side or the other. The guy that was filming it was driving right there beside it. Should Mr. Herring have wanted to move or not participate in what was going on, he could have easily driven out, backed up, after hitting the car, backed up and drove off. And once again, the presumption is that he had the ability to do that, and it was not that the car stopped him from doing that, that his truck was leaking radiator fluid, that the truck was badly damaged. And you heard the testimony from the state officer saying this car ain't going far. It's smoking and it's leaking fluid. That engine's going to stop soon enough. We haven't heard any testimony from the state to say that the vehicle was operational, that after the event when they came to get the vehicle, that it was able to drive. So him being in that position was at his own actions. He drove forward and hit the vehicle. Now, could he have driven off? From the testimony, from the views and the pictures, it appears so. But if the vehicle was not properly running at that time, based on the damage, based on the loss of radiator fluid, based on a lot of factors, that is why he was there. Not because of a car pulling in front of him. With that being said, he had the door locked, or it appeared the door was locked, so nobody could get into the vehicle. That is another reason that he was not able to get out, because he had his window down and the door appeared to be locked or damaged, so it was unable to be opened. All of these do not give rise to beyond a reasonable doubt. There are many theories that can be brought out there, but evidence has not been presented to confirm one way or the other. Evidence wasn't even presented to talk about the vehicle and was it operational after he accelerated and hit Miss Payne's car. So to try to categorize Miss Payne as the proximate cause of why he was there in the state he was, or why the vehicle was unable to move, or why he was unable to move, is not at the hands of Miss Payne. It's the hands of him and that vehicle and his actions. He had reasonable means of escape. He could have just backed up and pulled off. He didn't have to ram her car. He didn't have to accelerate forward. You saw the video driving down right to the left, and that car kept moving. Did not appear to be, any kind of traffic or anything impeding him from driving slowly by and watching it. As you look to the right side in one of the pictures, he didn't even have to go on the sidewalk. He could have scooted around her without even going on the sidewalk. No one said there was something on the sidewalk that was stopping him or impeding him from going that angle and moving on. So to say that she caused false imprisonment or is the cause of that is not been proven beyond a reasonable doubt. Not through the evidence that we've heard so far. And because they have not proven that felony, it would not give rise to felony murder, because the underlying felony of false imprisonment has not been proven. There's numerous theories out there. There's numerous things that occurred that were not even touched or addressed. And therefore, because the false imprisonment was not done by Miss Payne, then count 4 should fail, because it does not give rise to the felony that would justify the felony murder, which would take out count 8, the possession of the firearm during the commission of a felony. Therefore, based on all the evidence we've heard so far, the testimonies and the lack of testimony to explain, the state has not carried their burden beyond a reasonable doubt to prove any of these 8 cases. And I respectfully request this court to grant my directed verdict motion. Thank you.
It was a well-argued motion. I don't think any of them are going to succeed.
State's response?
The light most favorable to the state, there was evidence put forward on pretty much
Judge, as you're
all
aware,
those
the
counts.
standard is whether or not there is sufficient evidence for a jury to decide the case and the charges, and you have to view the light and the evidence in the light most favorable to the state. As it relates to malice and malice murder, as the jury charges that we have provided and that defense has provided, malice is not ill will or hatred. It is basically the intent to kill, and it can be formed in a moment. And I think that the evidence that has been provided regarding this defendant's demeanor and her conduct, including her own words on the 911 call, where she is cursing, screaming, telling the victim, "I will shoot you," which is basically her stating her specific intent to kill. And all of the witnesses who indicated that she was striking the victim. And then her own statement, basically, when she tells us all why she killed him, because he hit her car. And so the state has provided sufficient evidence for the jury to consider malice murder in this particular case based on all of the facts and circumstances that have been provided. As it relates to felony murder, aggravated assault, the uncontroverted evidence is that the defendant had a firearm, which is a deadly weapon per se, and that the victim, as testified to by the witnesses, was placed in a reasonable apprehension of receiving a violent injury. All of the witnesses indicated he looked shocked and confused, and that would be consistent with someone who is placed in a reasonable apprehension of receiving a bodily injury. Therefore, felony murder based on aggravated assault and the aggravated assault have been met. As it relates to the false imprisonment, the only thing that is required for the state to prove is that the defendant, as noted in the indictment, detained the victim without lawful authority. There is absolutely no evidence that she had any lawful authority to do any of this. And all of the witnesses described that the victim was cornered, that she trapped him, that she maneuvered to block him. The fact that he could have tried to figure out a way to back around all the cars and drive on the sidewalk does not negate the fact that he was detained by this defendant. The photographs, most of them, depict circumstances that existed once all of the cars were removed. That was the evidence from the witnesses in this case, certainly from Sergeant Ritchie, who indicated that those photographs were taken much later. So the traffic circumstances are more reflected in the video, and the fact that their vehicles are touching. Her wheels are clearly turned in order to block him in order to detain him in all of the photographs. He has nowhere to go. So he is detained as intended by the statute for false imprisonment, and therefore the false imprisonment and the felony murder associated with that, there is sufficient evidence for those to go to the jury. And in fact, Judge, all of the evidence is she's standing, even though she's telling him to get out of the car, she's basically standing there. She's right at his driver's side door, and she's holding a gun to him. So his choices are try to drive back up or try to get around her car even though it's blocking him in, or drive another way when there's a gun there. So he is very clearly detained, and we would ask that you deny the directed verdict on that as well. And as it relates to all of the gun charges that support that, I think the only other indication is a conversation about who pulled the trigger, and Judge, the state tendered I believe it's State's Exhibit number 22, if I may retrieve it.
Yes.
Which reflects her finger on the trigger very clearly. Even aside from that, the state's contention is that once the defendant is the aggressor, which is exactly how she has been described, what's in the victim's vehicle, his conduct, how he drove toward her vehicle, which again, you saw photos of the damage, a term that I use loosely, based on smudges, 2 smudges on her tire and her, I guess that's the wheel well fender. There is no evidence that this victim made any attempt to ram her or run her over. The indication is, as from all of the witnesses were asked, her demeanor, aggressive, very aggressive. Once she is noted as the initial aggressor, as the aggressor on scene, nothing that Mr. Herring did is relevant. She can talk about it, but it's really not relevant to her defense because she is no longer eligible to claim self-defense once she is the aggressor. And that is in the jury charge, the pattern jury charge.
That's
the
why
initial
they're trying
aggressor
so hard
cannot
to
claim
get the
self-defense and cannot use self-defense.
false imprisonment.
So we believe that the evidence in this case is more than sufficient to allow the jury to deliberate and to reach a verdict on each and every charge listed in the indictment.
If she was wrong to pull in front of his vehicle, then she's going to be found guilty.
So the court, having heard arguments from defense counsel as well as from the state, has determined that there is sufficient evidence for the case to be released to the jury and for them to deliberate and decide the case. The jury can view the evidence in the light most favorable to the state, and so the case will be released to the jury on all the counts 1, 2, 3, 4, 5, 6, 7, and 8.
If you can clarify, you just said the evidence would be released to the jury and most favorable to the state. Is that your decision, or?
My decision is to deny the motion for directed verdict, and because the court has determined that there's sufficient evidence for the case to be released to the jury to be deliberated upon and for them to decide the case on all the counts 1 through 8.
But there still is a presumption of innocence that goes with my client when it's released to the jurors, correct?
Yes.
I have said nothing that would indicate anything different.
She meant to say, I have to consider the evidence in the light most favorable to the state. Jury's not hearing this right now.
So before we broke on Friday evening, I did talk to Miss Payne directly about whether or not she was going to decide to testify or not to testify, and sort of gave the weekend for consideration. Has the defendant made a decision?
Your Honor, we're right there. I believe if we could break for lunch, when we come back for lunch, we could stay. I did have other witnesses that I have subpoenaed. I want to make sure that they are here. And based on that, I can make the definite decision whether she will testify or not. But if we just have lunch to go over what we've heard today and what we've discussed, we'll be ready to make that announcement afterward.
Okay. Thank you, Attorney Tucker. Anything further from the state?
Nothing from the state.
Okay. All right. So it's 12. I did instruct the jury to be back by 1:45. The court has to go through the jury charges. But it is my understanding that the defense will be adducing evidence.
I've got to make sure that my witnesses are present and that I can speak with my client, but our intent is to have something brought out. I just want to make sure the witnesses are here or available, and then I will discuss with my client.
Okay. All right. So at some point, I do want to review the jury charges, so I will do that after your decision whether you're going to present evidence or not. And if you are, allow you to do that, and then we can release the jurors and do our jury charges.
Thank you, Your Honor.
Okay. All right. So court stands adjourned until 1:45 p.m.
1:45 p.m. That's a long break. 1:45. That means we're back at 1:30. Okay. Let me tell you this. Listening to the argument for directed verdict, which I believe the defense did was probably one of his most eloquent moments. I think it swayed me. It swayed me to believe that she's guilty. Miss Saray says, "Can I represent the other side?" Let me first tell you why I think she's guilty, and realize that there is zero part of me that believes that when she was there on the side of the road, having witnessed the accident first, that she was looking for an opportunity to shoot this guy. There's none of that. I find that the if malice is found, I believe it occurred at the very end of this incident, that it occurred in an instant. I don't believe that, I gather that from the way she talks to the dispatch, from the way she's communicating. She's like, ma'am, no, I'm sorry, but I'm going to follow. This guy's going to cause an accident. I'll just be behind until the police can. I just don't hear malice at that point. So I believe it happened later. But I think it all comes down to the linchpin of whether or not she had the authority, if she was in the right, to pull in front of his vehicle and unlawfully detain him. Because in Georgia, if you instigate, and if she does something that, if she did that and didn't have lawful authority to do that, that's why the attorney's trying so hard to say there was room for him to get around and whatever. He couldn't go. He was revving the engine. He struck her vehicle, according to his own statement. It sounds like he was trapped. And if she did not have legal authority to do that, then she loses in that moment for this altercation the ability to use self-defense under Georgia law, because she started it. You can't start it and claim self-defense. So that's where I stand on that one. Now, it's much harder for me to decide which one of those counts this would rise to. Obviously, you've got the issue of who pulled the trigger, okay, and guilty of false imprisonment with malice. There you go. That makes her guilty, but it takes self-defense out of this. And now she's not arguing self-defense. At least she has not yet. If she testifies, she might, but she's not arguing self-defense. She's saying that she did not pull the trigger, which changes things a little bit. And there might be some lesser includeds, because if she says this wasn't out of self-defense, why did she pull her gun? Is that a crime in and of itself? I don't know, Miss R.A., you want to talk? I'm getting lost in my thought. Let's give you a spot.
Okay, so this is interesting. That I like what you have to say there. I think that's really insightful. For me, I just feel like I cannot get behind the anger or the frustration that is aimed toward her when it comes to what she did up to the point of shooting, whether or not she shot. I feel like if you're at an accident scene and you see somebody drive off, whether you think that they have just had their brain run into their skull, or they're having some sort of a diabetic thing, or maybe they're just confused, or maybe they're scared and they're driving away because they don't want to be the cops, whatever. That person just was in an accident and they need to stop for their safety, for everybody else's safety. It's not a good thing to have somebody wandering around who has a mental, concussion, right? I will just say this. One time, Scott and I stopped at an accident. This lady I don't know why, she ran off the road. She ran right into a telephone pole. And guys, shoot me now, because we stopped. But we got out and we got there. And this lady I don't know if she had a seatbelt on or not, but she had rocked forward. You could see the imprint of her head on her windshield, right? And she was dazed a little bit, and she said, I don't really know what's going on. I'm going to go. I'm just going to drive away. And we're like, yeah, that is your engine in your lap. You are not driving away. But she really thought she could. She really felt like she was okay and she should go, she can do this, right? This is what happens when you have a brain injury. You think you're okay and you're not okay. And in this moment, she couldn't. Her car was wrapped around a pole. She was okay as far as driving away. But this guy, he could drive away, and he did, and he should not have. For whatever reason he was driving away, he shouldn't have. So I don't think she was bad for following him and for saying, hey, that really needs to stop. I don't know if she was right for trying to block him in. Maybe she felt like there was no other hope because here they'd called for the police. The police were too busy to come and help at the scene. Maybe she felt like there was no other thing that could be done. I don't know on that. Are you laughing at me? No, wait, what are we talking about? Well, so stressful listening to us. Okay, so then she gets there, and let me just run a scenario by you guys, because I honestly don't know if this is the truth, but I don't know if we've heard the truth so far, not because people are bad, but because when we're under stress, we don't necessarily understand what's going on. Like in that call with the police, with the dispatch, she says, he took my gun. He shot himself with my gun. That is an excited utterance, and it is something that she thoroughly believed in that moment. I don't know if it's true, but she believed it because she said it right then. And then you heard the other person who was like, I don't know if she shot him. Wait, what happened? This other person off camera, they're telling me what happened. Oh, she must have shot him. Now she's all upset about it. I'm like, okay, I'm not believing that. Oh, I'm not done. No. Okay, but the point is, dang it, I lost my point. What was my point? Okay, hang on, I'll think of my point.
All right. So yeah, I don't think we're on the same page exactly, but this is what I'll tell you. Mrs. R.A. and I have witnessed multiple accidents, and we're the people who stop. I've witnessed one where the car had rolled and flipped off into a ditch, and I helped carry the lady up through her windshield, just covered in blood, wine bottles everywhere. I believe I was carrying a gun at the time. Just full honesty. I believe I was carrying a gun at the time. I had no idea an accident was going to occur, but we had just been camping. I had concealed carry permit at the time, and I was carrying one at the time, and I stopped it for an accident. I don't think the thought that I was carrying a gun occurred to me during the accident at all. Of course, I didn't get in an altercation with the lady. She just needed help. I don't know. There's a problem. I realize a lot of you are saying she shouldn't have followed, right? The dispatch said, we don't want you to follow. The dispatch says that because they don't want to get sued by telling somebody, yeah, we told them to follow and get the license plate. That's the purpose behind it. But it's not a lawful order. And so her saying, well, I'm going to follow because I believe this guy's drunk and he's going to cause an accident. For me, that doesn't get her in the wrong yet. I don't know. Man, this is a dilemma. This is a dilemma for me. Here's Mrs. R.A. again. One sec. We need to get you your own mic over here.
I have my own mic. Hey, 6 Volt, I have my own mic. Thank you so much. We just don't have an arm for it yet. Okay, so here's the thing. I hear you. Here's the thing. When she gets there and she gets out of the car, again, I'm seeing this through my own lens because I don't know if this is a confessional, but I guess maybe this is. I didn't know that this was illegal, okay? I was in a parking lot once, and I watched somebody come in on a moped, and they took the turn wrong. They were going the wrong speed, and they dropped the motorcycle. They wrecked, and I watched their head hit the pavement, and I was like, okay, whoa, you're not okay. Let me help you out. And they got up and they sort of shook it off and they were going to drive away again. I was like, yeah, don't drive away. And I blocked them in. Not because I thought they were a bad person, not because I felt the need to be all Karen or whatever you want to call it. I just thought, you're not thinking straight. You just had a brain injury. Let's just dial it back for a second. Let's just calm it down. Now, is the problem that she had a gun? I don't know. I don't think it's a problem to have a gun. She pulled the gun. In all of my altercations and all of the accidents I've been to, that's just never been a part of it. I'm not there to attack. I'm there to stop the bleeding. Let's get the ambulance there. I don't know why she pulled a gun. That to me is like, why did that happen? Everything else seems like that's reasonable. Let's stop this threat from hurting himself and hurting other people. But beyond that, I don't know.
Okay. Yeah, so she's outed us. Yes, you've pulled in front of someone and prevented them from leaving. Unlawful detainment right there. Guilty. Just kidding. Here's what I think needs to happen. I think from the evidence that we've heard so far, I think the jury's looking to convict. Okay, that's what I think. And I don't know which one of the counts or they might go with all of them. Okay, I think that's where it is. The problem is we don't have a complete picture. None of the videos, none of the witnesses, nobody saw everything happen as it happened. If the defense is able to, and doing this in testimony, if they are able to piece together all the pieces, okay, make a timeline without gaps, ideally with no gaps, where we watch the audio from here, the video from here, where it's all merged together in one big thing. We're going to see that what one witness saw and what the second witness saw and the third witness saw was just a piece. Was just a piece, and there was other pieces. And had they seen the other pieces, it might change their perspective, and maybe it will change the jury's mind. But they'll need to know the entire timeline. And unfortunately, some of that is only available from the witness, the only witness, and that's the defendant. And so I think she might have to testify.
Yeah, and I will say this, that as much as I look at this and think, I just don't think she's as bad as I'm hearing a lot of people say. I am so sorry that anybody got shot. This is a tragedy any way you look at it. This is so sad. I don't think her carrying a gun was a problem. I don't know why she pulled the gun. If I will say this, just I guess to kick an anthill, there were two deadly weapons at play there. There was the gun and there was the car. If she felt like he was using his car to try to use as a deadly weapon, then she would be in self-defense. But then there's your argument that says by the time she's out of the car, having blocked him, then she lost that defense. Okay, so maybe that's the case there. But I'm not sure. She wouldn't have been thinking that at the time. She would have just been thinking, stop. And yeah, I don't know. I can't relate to her at that point. I don't ever get out of my car and try to yell at people. That seems like a bad idea.
It is a bad idea. Don't ever get out of cars and yell at people at traffic accidents. That's what we've learned. I think in this case in the beginning, I tried really hard to be as impartial as I possibly can. And I think right now, having heard and looked at a lot of the law, specifically where it relates to self-defense, and heard the clearer audio from the 911 calls, I think she may have overstepped what she should have done. And I think she overstepped probably it started in driving erratically, okay? Man. I think that's where the first indicator was. Not that she was following the guy, because she had encouragement from the other gentleman on the scene who's like, "Hey, can you get the license plate? Can you get a picture of the license plate?" And she had even the dispatch wanted to know if she got the license plate. So I don't know. Man. This is going to be a tough one. We're going to have to think about it over lunch. What do you think? Yeah, should take lunch? I've got to run to the post office box. They challenged me to do that.
They challenged you? Are you going to do it on your feet?
No, I'm going to put my shoes on and take your car. If you choose to carry a firearm, I'm sorry, I got the hiccup suddenly. You must make responsible decisions, or you will end up in prison. I feel sorry for all parties involved, but she had no legal reason to pull the gun. Sniper, that we know of. I'm still trying to leave space for her because I can't account for how her shirt got ripped and how she got those injuries. The injury to the side of her wrist, up above her wrist, to the side of her forearm, the scratches on the back of her neck, the torn shirt. Something happens that nobody's talking about, and I've got to figure out what that is. Now, if she was okay with everything she did, like if his car had stopped, if what the defense attorney said and introduced, which I've only heard just now in the directed verdict motion, but if that guy's car stopped because it would not go any further, and she pulled over and happened to be right in front of him to help or to get him out, this is no longer necessarily entrapment, right? This could be different, and that might change things. She might still have a self-defense argument. But, man, he had the right to defend himself.
Yeah. Well, and that's the other thing. He probably was defending himself, and she probably felt like she was defending herself, and that's why it's such a mess. I think everybody calm down.
Beck, I hear what you're saying here. I really think she was just mad. We heard that. We heard her escalate. We heard the language. That's one of the reasons why we don't allow the language here in chat, because when you hear that, you assume somebody's mad and people get offended. It's escalating language when you're adding those expletives in there. And we heard that, and that was hard to hear. And yes, I did hear right before those expletives her saying that she would use that firearm against him. That there was the threat there.
I missed that. What did she say?
She said that she would shoot him if he didn't stop. Right before she said, "Get out of the effing car." Twice. That's what I heard. Anyway. All right, let's go. Let's all take a deep breath. First of all, thank you to all of you. This is a tough case to talk about, there's some tough issues in here, and the jury is going to have their work cut out for them. And I don't think, sadly, there are no winners in this case. It's not. It ends with big losses. And even if justice is done for the victim, it's still losses for family members and things like that. So let's take lunch and think it over and see if we can find up some better. Ashley says I never heard it. I heard it with my headphones on. I was listening. I had the volume cranked up, and I believe that's what I heard. Maybe I was listening for it, but I believe that's what I heard. Let's see. I think that's it. Let's go to lunch. How about that? Everybody okay with lunch? We've got a 1:45 restart time, which means we're going to have about an hour and 10 minutes of lunch. That's a long lunch for us. And then we're going to have the jury. Well, actually, we're going to have the defense. We get to hear if they're going to actually call any witnesses, or if they're going to have her testify in her own self-defense. All right, that's it. I think he grabbed the shirt and she stepped backwards and the shirt ripped. Possibly. Yeah, great stuff. Man, this is a tough one. I don't know, a lot of you, there's people out there saying I still can't get past the reasonable doubt. Other people are saying I've heard all I need to hear. It's proven. And everywhere in between. But thank you guys. It's a lot of fun watching this morning. We'll watch the rest of this case with you. I think it's going to probably go to the jury this afternoon. That's my thought. I think they're just going to have a single day of defense witnesses. It's not going to take that long. We might have a verdict as early as tonight, and we'll see. So far, objection count, we're at 31. Sorry, I can't get on the screen yet. I'm going to try to figure that out. 31 objections. 3 of them have gone the way of the defense so far, and of course, they lost their directed verdict motion as well. Directed verdict motion just means that they're asking the judge to rule and say, yep, you're right, the state didn't prove it. We'll throw those out. The judge said, no, if I look at the evidence in the light most favorable to the state, there's evidence to each of those charges, so they are going to go to the jury. All right, let's get some lunch tonight. When you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again at 1:30. So in about an hour and 8 minutes. We'll see you guys there. Bye.
Because he's the guy.